Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated kidnapping. You're also charged with theft of firearm. You're also charged with theft of firearm.
Scratch all that. Oh, that was terrible. I apologize. Scratch all that.
Have them send someone with more experience.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
LJ commentary on the case. Dati mihi Anglican, Maurice Verbus Latino.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for God's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Still learning how to do this whole YouTube thing. It's complicated, I tell you. There's so many buttons. All right, we're back. Congratulations to Sloth Life. Just 1 second. Let's turn the music down because it's super loud. There we go. Sloth Life, here we go. We'll put you on screen even. Congratulations. First in chat, Sloth Life. We're going to punish you with internet ownership. I know you're on light duty. So be nice to Sloth Life. Don't break the internet. She's doing what she can. Sloth Life, thank you very much for being here. Appreciate it. Everything IP related worldwide is your responsibility. All right, we're going to be jumping back to court with the tree trial. I don't know what else to call it, but they're coming back from lunch right now, and I'm here for it. Don't break her other arm. No, don't, please. Be gentle with Sloth Life. All right. Somebody just cleared their throat.
Don't miss the forest for the trees.
Welcome. Sorority sisters. This is sorority sisters gone wrong. They're suing each other. Can he get kicked out of sorority? Obviously, for obvious reasons, hopefully obvious reasons to you. I've never been in a sorority, right? I think, based on my understanding, it's because I don't qualify on a very fundamental level. Are there rules against suing fellow sororities? Is there like some sort of like a pact, lifelong pact that you back each other up and, we'll bless you. you guys wondered. The surveyor didn't remember anything. He had no clue. And then he told me he didn't do the survey. It was somebody else. He has people for that. Come on, sister, says Mary. Yeah, for someone who's in a sorority, I just don't know. When you're initiated, there's a whole swearing in process, I assume. It's not just being duct taped to the flagpole like it is in the movies, right? No, there's not. There were very few of my sisters I legit couldn't stand. There were a few I couldn't stand. My husband and I met a co-ed frat in college. If we had an issue with a different chapter and had these issues, bring it on. I guess it's okay to do. Sue away. Sue to your heart's content. Court TV broke the news a little while ago that Paul Canero's bid for a new trial has been denied. Not going to happen. So I thought I'd let you know that. Not granted. All right. This is a concept that doesn't exist in Brazil. Lady on the stand was using a walker. I think she just had surgery. She said she just had surgery. I don't know why her husband couldn't do any of the yard work, but maybe he also just had surgery. So none of us liked this one chapter from a different school. Strange. I skipped that whole, well, I didn't skip college. I went to college, but I went late. And so I was not the traditional student by any means. I was, in fact, labeled as non-traditional by the school itself. I'm like, why were you calling me that? Well, that's their name for somebody who goes to school after they get married and have like half a dozen kids, which is pretty much what I did. And I enjoyed school. I enjoyed learning. I enjoyed the classes, the interactions with the professors, and even some of the students were half decent. But the whole college life thing was not my scene. I mean, I'd show up if I had to film it. So if there's I filmed, like one of the events I had to film was called a nearly naked mile, and it's exactly what it sounds like. A bunch of people run a mile in almost nothing. And it doesn't start that way. It starts perfectly legitimate and normal. It's actually a clothing drive for the homeless and the poor, and you show up wearing all the clothes you don't want anymore, and you show up at the starting line, and it's because it's November. I think it's November 11 at 11 p.m. You shed all the clothes you're donating, and then you run for a mile, and they give you a T-shirt, and then you go home shivering. So that was fun. But other than that, I really didn't do much other than film sports. Sloth Life, RA, 2 days ago, Baker gave you a shout out looking for some guidance on kit needed for a meetup in June to live stream. YouTube has hidden a clip button, so I couldn't send it. It's 14 minutes in. I will look for that. And I'll reach out to him for sure. I happen to know some gear.
All right, we're back on the record. All parties and counsel are present. Anything to take up on behalf of the respondent before we proceed with your case? Mr. Miller?
Will I have an opportunity for a directed verdict motion?
Directed verdict?
Why don't we do it this way, just, in the interests of using everyone's time most efficiently. Just as a technical point, I think it'd be a motion for an involuntary dismissal. Since it's a bench trial, there are no verdicts to direct here. But I would say, why don't we just state the grounds to preserve them? And then you're going to be arguing many of the same points during your summation, and we can just bring it all up there and again. So, and I'll defer ruling.
Points. There's no claim for nuisance. The claim of nuisance may not be brought based solely on a claim of physical taking of property. That's what's going on here as far as the trespass. So we would make a motion for directed verdict on any nuisance claim that the petitioner added on Tuesday. Same goes for the negligence and negligence per se. They're barred by the statute of limitations. They were added on Tuesday. And the
applicable statute of limitations here being 2 years? What would it be?
20 till the filing of the lawsuit. It's more than 4 years.
4 years. All right.
And then the motion for directed verdict on the covenants and restrictions in our memorandum, trial memorandum, where a deed of sale does not mention certain restrictions. But the property owner had notice of such restrictions. The restrictions are binding upon the purchaser. Well, that's the other point, but Ms. Martin has testified she was well aware of the fence, well aware of where it was located at least. At the point in time when she moved in, it's gonna be our evidence, she connected to it, but she said she did not build that new fence on the side of the house. But nonetheless, she was aware of the fence. She bought the property. She lived there for almost a year before she started making any noise about the trespass. And that agreement runs with the land, runs with the title, based on the case law we cited in our trial memorandum.
Well, what evidence has been introduced so far that any kind of formal agreement or covenant was?
Doesn't require a formal agreement. All it requires is notice under the cases we cited that she denied connecting to the fence, but nonetheless she had notice of the fence, the full enclosure, and under the case law we cited in that trial memorandum, it's not required that there be a formal agreement.
She would have to have noticed that the prior landowner came to some kind of understanding or acquiescence, or I'm just saying she didn't introduce testimony about what the prior landowner was up to. So
we introduced testimony that she knew about the fence.
But she showed up, she sees a fence there, but she has no idea of the circumstances of how it got there.
I think that first case, Your Honor, Atlanta Association of Baptist Churches versus Gowan. surrounding the purchase lot. The deed contained no notice the lot had been purchased would itself be subject to such a restriction. The purchaser was nevertheless on notice that said property could not be used to build a church. That, in effect, is the same thing going on here. She had noticed that there was a fence in that location. She derived the benefit from it for at least a year before she started.
She didn't testify that she derived a
making,
benefit.
Allegations of trespass. But that would be our additional point, Your Honor.
Okay, well, I'll take a closer look at that, and I'll defer ruling on those motions. They're preserved. And so I think we would then transition to any evidence that the respondents wish to present.
We would call Miss Brandy Thomas.
All right.
Here we go. Brandy Thomas takes to the stand.
And I have the correct understanding that I've used up 43 minutes of my 2 hours.
No, that's been counting down from 2 hours. So you used 1 hour and 20 on cross.
Used 1 hour and 20.
Yes, my name is Brandy Thomas.
And
That's
talk fast.
BrandyThomas.
And I am a sorority sister.
Okay. Tell us first, where do you live?
I live at 9 Northeast Atlanta, Georgia, 30319.
And when did you move in?
We moved in April 2018.
And Miss Martin is right next door at 920
She is.
Wendover Drive. And she moved in April 2023, right?
I try.
correct.
I try.
So you guys lived there for about 5 years before she did.
Of Georgia.
That's correct.
Now, what do you do for a living?
Right now I'm transitioning to a new role. I'm Vice President and Chief Audit Executive of Uber Technologies. That's coming up. But prior, I was Vice President and Chief Audit Executive of General Motors. I also sit on 2 boards of directors. I sit on a public company board of directors called Next Power, where I'm chair of the audit committee. And then I serve on a private company board here in Atlanta called Serta Simmons Bedding, where I'm also chair of the audit committee. I also sit on the NomGov committee, as well as the compensation committee.
So you're between jobs. Is that what you're saying?
Now,
Holy
you're married to
smokes.
Cedric, right?
I am.
And do you have any children?
We do. We have 2 children. Our oldest, CJ, Cedric Jr., is almost 21, and he is a junior at NYU in New York City. And our youngest, Bailey, is 14. She's in the 8th grade at Pace Academy.
Okay, and
Soon to be
do they
Harvard.
live at the address?
They do. Well, CJ is away at school a lot of the year, but Bailey lives with us at 930 Wendover. That's correct.
Okay.
She says Uber Technologies. Is that like Uber?
Share on this picture.
We need to make sure you're added as a co-host, and then you should be able to share away.
Share it to your heart's content. Judge is doing some legal reading on the motion that was made during the break. She's a big deal. She's the real thing. Holy smokes. Why doesn't she just buy the whole neighborhood? I think she could. Buy the neighbor's house, demolish it, make a beautiful view. Everybody has a price, you know, the whole make me move thing. There's a price where they'll sell their house. Sounds like she could do that. All right, let's see what exhibits.
Now, you heard Ms. Martin testify earlier that she did not build this rather new-looking fence on Defendant's Exhibit O. Do you see that?
Going
Brandy?
straight for the
I do
perjury.
see the exhibit, yes.
Here we go.
Now, is that true?
That is not true. Bianca, I'm shocked that you would be up here.
Only address
I'm sorry.
me. You don't need to address anybody
Sorry.
else.
I'm shocked that she would testify that she did not build that fence. As a matter of fact, to Bianca's own testimony, when I came over and welcomed her, we had a conversation about how it was great that she had made so many improvements on the house because the prior homeowner had done absolutely nothing to maintain it. So anybody can see in this picture that the fence is brand new and was recently built.
I told you there'd be surprise.
And
To your knowledge, when did that fence get constructed? Shortly after she moved in?
It would have had to be constructed shortly after she moved in, yes.
And it was connecting to your fence, which is the older fence?
That is correct. Well, you can see our fence was built in 2020, so it's older, gray, weathered. This is a brand new fence that was put into place by the current homeowners.
Okay. And now you remember the testimony regarding a code enforcement complaint?
The first of that I heard today. So I remember the testimony, yes.
Did you guys make that complaint?
We did not. As a matter of fact, to Brianka's own, Ms. Martin's own testimony, there was a code violation allegedly about our turf. I don't know why we would call code enforcement on ourselves. It's not a logical argument, and we certainly never called. We have really worked hard to take the high road over this last 2 years, and I'm really surprised that we are here. This could have been resolved from day one in April 2024 with a simple conversation.
Now, she had mentioned something about in her prior testimony about how you guys were sorority sisters, but you're really not that close or anything. Does your sorority have any sort of theme with the sorority sisters that you would like to tell the court about?
Oh, this
There
is going to be
is.
good.
So Ms. Martin's right. We probably pledged at different times, but we all subscribe to the same tenet.
Which is?
One of our major songs says, "We help each other." And I, through this whole thing, have tried to be helpful to Ms. Martin. I've tried to give her the benefit of the doubt. I've tried to communicate with her, and I've adhered to that testimony. And my hope was that Ms. Martin would behave in the same manner, and I have not experienced that.
Okay. So you heard also Ms. Martin testify that she had learned from the landscapers that the fence was on her property. Do you remember when the landscaping that she did actually occurred? Did it occur before February 21st of 2024 or after?
Did the landscaping occur? So her property was largely unlandscaped for a very long time. So to the best of my knowledge, her landscaping happened after February of 2024.
Okay. And did you receive an Amazon package in the last few months?
I did. It has been impossible to communicate with Ms. Martin about anything. I have reached out and offered many, many attempts. One of the most recent was a misdelivered Amazon package where I've been told to communicate through her attorneys. I can't even go over there and say, "Hey, here's your package." So I reached out to her attorney, no response from her, no response from her attorney. The package is sitting in my garage. I don't know what to do with it. I'm afraid to get rid of it because she's so litigious. I don't know what to do in this case. It's been perplexing for 2 years, and it's been an exhausting endeavor.
And did you not notify her counsel once you received that Amazon package?
I did.
By mistake?
I did. It was misdelivered.
Now, you saw a picture identified as P5, which showed a stake and some construction, something in the right side of that picture. It was P5. What was going on at the point in time when you told Mr. Klein that he did not have a right to come on your property?
We had a construction project going on, and it was a major construction project. So there were, at that point in time, I think, well, as we discussed, I had not retained any counsel. I was in good faith attempting to negotiate and go back and forth and write letters between myself and Ms. Martin's attorney. So it's me, Ms. Martin's legal team, Ms. Martin's experts, all of that. And so by trade, I am a risk manager. It felt incredibly risky given that construction project and given everything that I had experienced to that point to just carte blanche allow someone on my property for a purpose that I didn't understand. And I'm also glad that I didn't, because when I finally retained counsel after Ms. Martin sued me, I was advised by my attorney to say, "Hey, before you even do that, it's a good idea to put in an access agreement, both for your protection and for hers. And that's what ended up happening.
Now, the settlement agreement or the settlement proposal that was offered back in November of 24 by Miss Melanie Nealis, it talked about an arborist that was had to be pruned, the tree had to be pruned back to the satisfaction of arborist. Who was going to pay for that arborist in November of 2024 when Miss Nealis made that offer to Miss Martin?
We would have paid, we ourselves would have paid for that arborist and been glad to do it.
Okay. So let's jump back to the beginning. In 2018, was there a chain link fence that ran parallel to the wooden fence?
There was a chain link fence.
Please tell the court how it is that you built this wooden fence back in 2020, running parallel to that chain link fence.
So in January in 2020, we got a pandemic dog. And that side of the house between where our home was and the chain link fence was the side that we decided would be where the dog went to the bathroom. And so as a courtesy to our neighbors, we approached them and said, hey, we would love to protect your line of sight by building this fence. And we talked and we agreed. They had dogs. We're all dog lovers. And they said, we think that's a great idea. And I said, well, I'm going to put it right in front of the existing chain link fence, which we understood to be the boundary line at that time. So there was agreement between the previous owner and ourselves for the construction of the wooden fence, and it benefited everyone. Our yard is pretty meticulously landscaped. That's the only sort of unattractive side of our yard. It's also where our trash cans sit. And so we did it as a cordial, we had a very cordial relationship with our previous neighbors.
And that's where your dog went to the bathroom.
And to this day, that's where that is.
All right. So exhibits 13 and 14 are pictures
of poop
that are already admitted to evidence. Are pictures of this black chain link fence at the point in time when you bought the property?
Yes, that's correct.
And then exhibit B is a picture of the fence removed. The fence has already been removed, but it still has that black post there.
That's correct.
And that black post went to the chain link fence, correct?
That black post is in the same location where the chain link fence was.
Okay, now tell the court a little bit about what happened with the neighbors, the prior owners in 2021.
Yes, so the prior owners in 2021, we had debris continuously falling on our home and property from that tree. There are large limbs that fall constantly. So it fell on cars, it would fall on our home.
Periodically is a better word.
Even we had a caregiver that would come, and I had an assistant at the time, and they would constantly complain, in addition to my father, about things falling from that tree. And so the previous homeowners, although they didn't remediate the tree, they said, hey, we'll pay for any.
Your Honor, your side.
They said to me.
Well, hold up.
It's still
Any
hearsay.
response, Mr. Chairman?
Still hearsay.
Just explain her conduct, Your Honor, in building the fence in the first place.
Not fact of the matter.
But it would not be
Allowed.
to the issue of whether the limbs were in fact falling or, but with that caveat, noted that it's not for the truth of the matter. You can continue, ma'am.
Okay. They agreed and paid for damages done to our house. We had our roof punctured, we had water damage. They would come out and have their crews, and we never had to see a dime. We did not pay a dime out of pocket. They would just cover the cost of those damages. There were times where we didn't ask them, just like we didn't ask the Martins, to cover the damage, just to preserve the cordial relationship. We're all very busy people, and I'm not interested in coming to them for every concern that we have. We try to be good neighbors.
Okay. And there's Exhibit D, which is the invoice, and a photo of the wooden fence back when it looked, before it was removed as, I guess it's D1. Let's jump towards the text of February 4th, 2024.
Okay.
Now, I'm not going to go through it, but because we've been through it before, but Ms. Martin seemed to testify that because you put in there per Georgia regulations, if you have been notified that a tree is threatening a property, the burden of repair falls on the homeowner where the tree resides. Now, why did you put that in their text? And why did you send that text to her? What happened around early February of 2024?
Speaking to the intent of that text, I wanted to make her aware of the concern with the tree. Primarily, my thinking was, hey, you've lived in the house less than a year. You could go back to the people who sold you the house and you could say, hey, you didn't disclose that this was an issue. I was letting them know that it was an issue that was disclosed. And I assumed that she would go back to the homeowners that sold her the home and say, you never talked to us about this risk. She could have negotiated, and I would have been happy to support her. I would have provided anything that she needed to support that because they knew it, we knew it, and it was very well documented. The second piece is we moved to Atlanta in 2017 and we bought the home in 2018. We didn't know at the time about tree regulations. I wanted her to know this was not personal. This was not something I thought or made up because we had our own education around trees and what to do. And, you know, how we started this conversation this morning, what the tree laws are, which we came to understand, hey, if you notify someone on your adjacent property that a tree is a risk and you do it in an official way, that's why we sent it via FedEx eventually, then your obligation at that point has been served as a homeowner to put someone on notice. So I just wanted to share my knowledge with her. By nature, I'm a very detail-oriented person. It's my job. It's what I do for a living. And so the length of the text was more explanatory and just trying to be helpful and giving her good context for what we were talking about. At no point was it to threaten anything legal or civil or anything at that matter.
Now, at the end of that text, there's an indication that Ms. Martin said, I don't really get into outside stuff, but I did share your messages with Keith. He said he's available to talk this weekend. Did he ever come by and talk this weekend?
He never did.
The weekend following that text?
Never did.
Okay, now what happened on March 23rd,
So
2024?
Certainly. March 23rd, 2024 was a Saturday morning, and we woke up delighted because we heard chainsaws and we saw in the middle of our yard, there were Miss Martin's people that she had hired to take down those 3 trees in her front yard, standing in our front yard, belaying large branches off of a tree. And I remember at the time I thought, this is great. I'm like, oh, she didn't respond to us, but she is biased to action. I like this. I think this is great. I was thinking, how could you ever take down 3 large trees for cosmetic issues and not address the clear and present danger of those limbs? The second I received a communication like that, if it was from Ms. Martin, I would have acted on it. So we allowed the whole day to go by because I wanted to give the benefit of the doubt that the tree would be remediated. And as the day drew nearer and nearer and the workers began to conclude their work, that's when we realized, oh my goodness, we should have a conversation with them because I don't think this includes the tree that we've been trying to get resolved or the limbs that we've been trying to get pruned back with them.
No, are you aware of a conversation or attempt to have a conversation by your husband, Cedric, with Keith?
Yes, I suggested he should.
What happened in that conversation?
My understanding when Cedric came back, he told me that Keith blew him off and didn't seem to know anything about what we were talking about and said, I guess I should have a specialist come out and take a look at it.
Did that ever occur?
It did not.
Now, there's a letter G1 that's marked as G1. It's March 27th, 2024. Why did you send that letter to or drop it off in Ms. Martin's mailbox?
One, we said we would. So in my very long text to Ms. Martin, we gave her a heads up that the letter was coming. We wanted to share with her what we had shared with the previous neighbor. And by the way, we had shared another one with the neighbor on the other side. So this wasn't any different treatment than we had done with our neighbors. And it's very commonplace in our neighborhood to do that. Second of all, we hadn't received any follow-up or any response about something that was a clear and present danger to our home and our property. And so at that point, what else could we do besides, provide official notice that this tree was a problem, because that was our understanding of what we should do to protect our home, our property, and our family.
So did you receive any contact after you delivered that letter in March 27th of 2024?
I did not.
And then the next receipt was this April 23rd, 2024 letter from Mr. Klein, correct?
That's correct.
And did you understand this letter?
Not at all. I was shocked.
And at the bottom of that letter, what was your understanding as to when you were required to remove the fence?
There was no requirement to remove the fence. That was not my understanding at the time.
It states that once the updated survey is completed, we would request you move the fence.
Yes, that is correct.
So what was your understanding as to when this survey was going to be completed?
Yes, I misunderstood the question. I once the pin was located wherever it was at that point. But at that point, when I received the survey, I didn't even know what a pin was or what we were talking about. It also included an exhibit that was on an 8.5 by 11 sheet of paper. It was so small, it was almost in one corner. So it was even hard to legibly read the exhibit that was sent to my home.
Okay, so after you received this letter on April 24th, what did you do as far as trying to contact Ms. Martin?
So immediately, Ms. Martin testified that it was 9:00 at night, which that's correct. When I texted her, we had company that evening. Our pastor was over our home, and he handed us the FedEx envelope on his way out of our house. And so immediately I opened it and I read it and I was surprised. So I immediately called her and I said to her via voicemail, "What is this all about? Why are we talking through attorneys? Brianka, I don't understand. I don't understand why we're communicating this way. Everything that I've asked of you, I've always given you a heads up. We've always had open communication. I would prefer not to communicate through attorneys. I would prefer to speak to you neighbor to neighbor." Then I called her once. Then after I hung up, immediately I sent her a text saying, "Brianka, let's talk neighbor to neighbor. This is the first I'm hearing of this. I would also love to follow up and talk to you about the tree, but I will not be calling your attorneys. I would like to have a conversation with you, my sorority sister, one-to-one in a neighborly conversation. Let's talk. By the way, see the rest of my texts. This is the way you engage with a neighbor when there is a concern. You speak to them first. You don't lawyer up. I don't get it."
Now, during that summer of 24, you wrote a letter on May 2nd,
Yes,
like immediately after the letter of the 24th of April.
correct.
And you wrote another letter in July after receiving a letter from Mr. Klein on June 20th.
Yes.
Just very briefly, why did you write those letters and what did you say in the letters?
Well, the first letter was to clear, I am not an attorney. I am not a surveyor. I am not a real estate agent. I had not dealt with matters of PINs. I did not understand the issues that were being asked or what was being asked of me. So the May 2nd letter was clarifying questions so that I could get my head around what we were even talking about. My hope was in that time that Brianka would respond to an email or a text and that continued open door so I could get clarity, but I had no recourse but to speak through attorneys. And that was a slow process. I wanted to get this done. The letter on May, what was it? You asked me about the other
July
letter.
25th?
July 25th was also further clarifying and thanking her lawyers for responding and saying, "Hey, I would like to get my own experts assembled and get my own assessment of what's going on because I'm still not an expert." And I say very clearly in that memo, I am interested in resolving this as quickly as humanly possible. Give me time.
And then did you receive any contact after you wrote that letter on July 25th?
I didn't. And that surprised me because we had established a period or a practice of I would send a letter, they would at least acknowledge receipt through a response. And I never got a response, but I immediately sprang to action to follow through on what I committed in that letter to do.
Did you try to get a survey in August of 2024?
I reached out to a company, yes, on August 10th, and I received 2 quotes, one for about $800 and one for about $1,300. There were 2 different kinds of surveys. I didn't understand the difference between the 2. $1,400 about, I believe, the second one was.
And why didn't you follow through on getting that survey or get that done in that time period of August, September, and then October is when the lawsuit was actually filed?
Yes.
What was going on?
Yep. So a couple of things. There were some practical reasons there. I mentioned in the exhibit earlier that there was construction equipment and materials in our driveway. There was an active construction site in the back of our home. And so, again, at this point, it's just me, Ms. Martin's full legal team, all of the experts that she had brought to the table. At this point, I've not engaged anybody to help or support me. And so given the fact that the back of our home was an active construction site, I thought it was wise to seek counsel as to what would be the right way to do this. Also, by that point, I had made no less than 3 attempts to reach Ms. Martin directly so that we could settle with no response. At that point, the trust wasn't there. So we're talking an active construction site. We're talking about somebody who is not responsive, immediately litigious. And at that point, also, she had derived benefit from the fence because she had a secured place where her 7-year-old son could play. Like there was a clear benefit there. And there wasn't anything as in regard to in the letter that would make me feel like this was escalating to the point where I was shortly after going to receive a lawsuit. Now, in the background, what's happening here is that I travel extensively for my job.
Take Uber.
I was contacting the survey from Zurich, Switzerland person. I then move on to France. I then go to South America. I make 2 domestic trips, 1 trip out to Scottsdale to deal with a health issue. It's back to school. So it's an incredibly busy time. I also in that time have board meetings for General Motors. I have my board and committee meetings for Next Power. I have my board and committee meetings also for Serta Simmons Bedding. So amongst all of these things going on, I am actively trying to move this forward. I also remembered that that construction project had a survey associated with it. And so also then from Paris, I reached out to the construction people and I said, hey, I think you all did a survey.
From atop of the Eiffel Tower.
Can I use that? And here's the situation. They said, we don't think it will be helpful because it's on the other side of the yard. It really doesn't concern the area of the Martins' property. And so my next step was to then go back home and see, because I have the drawings of the original plans of our house, to look at that and see what the encroachment issue might be. So I'm through all of this very diligently working and taking steps to, in good faith, move this forward as I committed in the letter.
Now, the lawsuit gets filed in October, and tell the court just generally who did you retain first, and Exhibit 5 of the defendants is what?
Right.
If you could take a look at that.
Exhibit 5.
The emails from Ms. Nealis.
Yes. 1 second.
When you're ready, we have
Can you
a
tell me
song
what
to
tab
play.
that is in the book?
Well, in November,
Yes,
you retained Ms. Nealis, correct?
I did. Yes, that's
Right.
correct.
And what was the offer that was made at that point in time?
The offer, well, first I'll say before that, I expected to hear back from Ms. Martin or her attorneys, and it went silent until I received that lawsuit. And at that time, I said, oh my goodness, I can't believe this. At that time, I still don't have legal representation. So I called Miss Nealis and I said, hey, you know what? I just want to resolve this thing quickly. Can you put something together where we both can win? Agree that if she prunes the tree back, that we will move the fence without even continuing this survey business. Let's just get this over with. And she agreed to put that together and put it in front of Mr. Klein and his team and see if we could really get this resolved.
And the emails, you've seen them before, those are all true and accurate of her discussions with Mr. Klein, correct?
They are.
And she was retained for about 2 weeks, right?
She was retained for about 2 weeks because I really felt that this would settle quickly.
And did you hear from her as far as what Mr. Klein thought about the settlement?
I did. She sent me a text message saying that Mr. Klein thought it was reasonable, that it should settle quickly and amicably, and he thought it was a fair settlement.
So I think her neighbor's chasing money.
So the lawsuit's filed, you can't get it settled in November through Ms. Nealis. And then there are 3 extensions of time to file an answer. What was your understanding as to why those extensions occurred? And just tell the court a little bit about that.
I think this is an important detail because we presented the settlement offers, and then it would go silent. We would not hear anything from Ms. Martin. We would not hear anything from her attorneys. And so what they were doing is running down the clock. And then at the last minute, we're waiting for a response, and my attorney would reach out and say, well, can we get an extension? So it feels like it's been characterized so far that, you know, Ms. Martin and her attorneys graciously granted all these extensions. In every case, it was we had presented something and they were not moving forward on providing us an answer. As a matter of fact, on that settlement offer, we never received a response. We had that, I had that text message exchange with Melanie Nealis saying he felt like it would settle, and then we never heard anything, and the agreement expired.
Okay, so it never settled. And then tell the court a little bit about what happened in February with this police officer.
Yes, okay. So in February, that was after we granted the access agreement to them. So immediately when we weren't able to settle, I did not want to use any more of Ms. Nealis' time. It's correct. She is a licensed attorney, but she was a friend of mine who agreed to represent us for that limited purpose. I paid her for that. And so I then retained King Buttermore, and he immediately provided an access agreement on February 2nd. I believe the same day he sent it is the same day that Cedric and I signed it, immediately saying, okay, we agreed to settle without you having to do all this. We agreed to do what you wanted to do, us to do. But if you insist on going back and finding this pin for whatever reason, let's immediately give you access.
And that was February 2nd of 25.
It was February 2nd of 2025.
So that would have been before the answer was filed.
Correct.
And what happened with the police officer?
Yes. So I am working from home, February 2025. And a police officer comes to my home, and I'm shocked. I answer the door, and he says, sorry to bother you, ma'am, but your neighbor. Oh, how am I supposed to describe it?
It's part and parcel of her contact before the litigation occurred or joined, Your Honor. I think it's admissible.
Can I respond to that? Oh. Well, I mean, right now, the hearsay alleged is, I'm sorry to bother you. I don't really know what truth is asserted there, but to the point, we'll see what actually is coming through there. We shouldn't just relay a conversation verbatim, but we'll see what the actual content is. No matter what, it's not it'll be for to show issues of intent. So
continue.
Overruled.
You want to hear the story. I'm vested now.
He said, we got a call from your neighbor, and she is alleging that your landscapers are throwing trash into her yard. And I said, well, my desk faces out. I can see almost my entire front yard, which is where the landscapers were at that time. And I said, they wouldn't do that. They're incredibly professional, but let's go out right now and see what the matter is. And so I walked the perimeter bordering Miss Martin's property with the police officer, and we find nothing. They had been doing mulching. And we found nothing, and I took some video at the time to show that there was nothing on Miss Martin's property at that point in time. It was just beautiful landscaping that was done. And so the police officer said, I don't see any evidence of what Miss Martin is talking about. And he says, so then he goes to my driveway and then contacts Miss Martin. I go to my landscapers to just reassure them and say, I'm so sorry. I know it's weird that the police are here. Everything is okay. When I walk back to the driveway is when the police officer had Miss Martin on speakerphone where she was screaming. I heard it myself at the police officer for not filing a police report, insisting that a crime had been committed. I stood there and listened, and I said, Brianka, again, this could have been a phone call. We could have just talked. If you had a concern, immediately Brianka hung up on the police officer. And police officer said, ma'am, you know, I don't see any evidence of anything that she's saying here. And he then left.
Now, when was the access to the pen actually, when did the access to the pen actually occur? Was it September 30th of 2025?
It was end of September 2025, but we did not receive any notice that the pin had indeed been found. At least the first I heard about it was at the end of October 30th, 2025.
And that was because the fence had to be dismantled in order to get to the survey pen?
That is correct.
Or at least that was your understanding, right?
Yes,
okay.
That is correct.
Now, what occurred in February of 2026?
February of 20.
When your roof got damaged and Shingle Pro had to come out.
So there was another storm that came through, and my roof was punctured due to a falling limb from the tree. We have pictures that show the perspective of the tree from the house. That is the only tree that actually is at the angle that would do that damage. And what happened was the roof was punctured, and once again, we had water damage into our primary bedroom. So the places that the arborist said were in danger, indeed, we've got more fall down from that. And so I hired a roofing contractor to come out, repair the roof, and then we had to have some interior drywall repair and repainting of a ceiling to remediate the damage.
Okay, and Exhibit K is that exhibit which shows that estimate or that invoice which shows the cost $1,075, right?
That is correct.
And you had to pay for the tree inspection that occurred on March 3rd as well.
That is correct.
And that invoice is in evidence, but that was $425, right?
That's correct.
Okay. So when did you actually obtain or see for the first time this Exhibit N, which is a Save a Tree estimate for pruning back the tree, which was $1,300, Exhibit N?
Oh, incredibly recently. I would say within the last couple of months, it was presented to me. I was surprised that Ms. Martin even got the estimate. I didn't understand her intent there.
Okay, so we're getting short on time, so I'm going to go ahead and ask you the last few questions here. When you look back at this entire neighbor dispute, is there anything that you would have done differently?
I believe that I treated Brianka with fairness, with respect the whole time. I tried to understand the situation at hand. I was biased to action in terms of following up on everything. I put multiple settlement offers on the table. I left the door wide open to conversation with her, and that is something that I never, ever received. It was never reciprocated. At any point, we could have had a conversation. This could have been over April 24th, 2024. Instead, here we are 2 years later in Fulton County taking court time to do this, which I will never understand.
And
it could be in Paris right now.
Did the only thing you really wanted was to prune the tree back?
The only thing I ever wanted was to prune the tree back. And honestly, after we put the notification in their mailbox, I was done with the matter. We could have had a glass of wine after that, just like we did with our previous neighbors.
So what would you like the court to award here? as far as you're concerned?
Yes, I would like the court to award my attorney's fees for certain. We did not have to go here from moment one. I said, let's talk. Why are we going through attorneys? I've spent tens of thousands of dollars defending this lawsuit after putting multiple offers on the table. She never had to retain an attorney, not once. That was never a requirement. There was nothing in my conduct, there was nothing in my behavior that said, yes, you need to lawyer up. So I would like the return of my attorney's fees because this has been a long road. I have I just want to say, I have a communication to my lawyer, King Buttermore, where I say, I want to express candidly but respectfully that I'm struggling to understand the expectations at this point. It appears that Brianka continues to delay and sidestep obligations in her own lawsuit. We push back in the moment, yet the burden repeatedly returns to us to fix the situation, requiring us to rearrange our schedules to accommodate her missed commitments. She maintains a regular work schedule. Meanwhile, I balance a demanding job, serve on 2 boards, and travel frequently. Even so, I have worked hard to remain flexible and to uphold my responsibilities in what has become a remarkably petty situation of her own making. Her repeated delays continue to interfere with my ability to participate effectively in my own defense, while she seems able to dictate timing entirely on her own terms.
Statement.
I am simply sharing the reality that her ongoing reliability has had meaningful consequences for me, professionally, personally, and logistically. Her delays have affected my work schedule, required unexpected time off, disrupted our home life through unannounced visits from individuals she has hired, and generally imposed burdens that she herself does not seem to experience. It fits a consistent pattern over nearly 2 years. I sent this last fall to King Buttermore. From missed communications by her counsel to her own failure to meet obligations, it is difficult to understand how there can be no remedy or consequence for such sustained, documented behavior. And as a result of that, I do believe that I am due my attorney's fees, and I just want her to enjoy her home in peace.
Thank you. Your witness.
Well.
Thank you, Your Honor. Good afternoon, Mrs. Thomas. My name's David Klein. We never met in person. Good to meet you, though, here today. I do have some follow-up questions for you here, and I'm going to be putting exhibits up on the screen. So if you need me to zoom in or anything like that, just let me know. I want to start out with an affidavit that you submitted in connection with this proceeding. And
just close all tabs.
Give me 1 second.
Close all the tabs.
Can you see that okay?
I can, yes.
All right, so this is Defendant's Exhibit J. And I want to go down to, this is your affidavit, is that correct?
That is correct.
Okay. And this was submitted February 2nd of 2026?
That's correct.
Okay. Under paragraph 5, can you read that first sentence to me?
The subject fence, as constructed prior to the sale of the Martin property to the petitioner, is shown in the exhibits attached hereto, marked as Thomas Exhibits 1 through 6. These pictures are true. Just the first sentence?
Yeah, just the first sentence. Mm-hmm. And so I'm going to go down to this first exhibit here, the Exhibit 1.
Yes.
So this is what the fence looked like at the time prior to the purchase of the Martins' purchase of their house. Is that correct?
That's the fence as it was constructed, yes.
Okay.
It was there when they bought the house.
And your testimony previously was that the side fence here that's connected to your fence, that Miss Martin put that in. Is that correct?
The previous owners never did any improvement, and so yes, Ms. Martin put that in.
Okay, but you're saying that this, in this affidavit, that this is what it looked like at the time the Martins purchased the property?
No, I'm saying what the straight fence, so the one with kind of the grass stain at the bottom, is what it looked like at the time they purchased the property, not the connecting fence.
Okay. Again, paragraph 5 says the subject fence is constructed prior to the sale of the Martin property. Strike that.
Yeah,
you indicated that you're both sorority sisters. However, you went to different schools, correct?
We did.
You didn't know each other before Miss Martin moved in?
We didn't.
All right, I now want to go to Respondents Exhibit 2.
Yeah, that subject fence thing was the key line. Still with the
And I want
witness
to
on the
scroll
stand
down
being
to
grabbed.
that March 27th letter
Yes.
that was attached. So here's that letter, is that correct?
Yes, that's the letter.
You and your husband wrote that letter and placed it in the mailbox of the Martins?
We didn't play. We sent it via FedEx so that we would have tracking to demonstrate if there were damages that we had notified them officially.
Okay. And did somebody help you and your husband write this letter?
They did not.
So I want to read the first sentence of this third paragraph. It says, according to Georgia law, if properly notified, it is the responsibility of a property owner where a tree is rooted, especially if the tree is identified as being diseased or dead by an arborist, to take financial responsibility for damages done to the reported property. Where did you get that information from?
We learned, so we moved from California to Atlanta in 2017 and brought our home in 2018.
Okay.
And through the dealings that we've had with trees with our previous neighbor, we educated ourselves on what our responsibility was and what our neighbor's responsibility was and how we could protect ourselves. In addition, behind our home, there was a large tree that went from not the Martin side, the other side, and fell across the back ravine and hit a house on Peachtree Dunwoody. And so that was incredibly scary to us, given the history of our home being bifurcated into the previous home. So we did our research, and it was
Great
that
word.
that's our understanding of what Georgia law was. So it was independent research.
All right, this last sentence of that same paragraph says, however, allow this letter to serve as notification that going forward, unless this tree is properly addressed, paying for damages caused by this tree will now transfer to the Martin household. Do you remember writing that?
My husband wrote it. I remember reading it, yes.
Is that a fair and respectful way to treat your neighbor?
Absolutely, especially since when I first notified her of the tree damage, I said, look, we haven't talked about this. I'm not asking you for anything at this point because that wouldn't be fair. But we at that point, she had committed to talk to us about the tree, had not followed through, then had other tree work done on our property and had not followed through to do anything about it. And so I think it's well within our rights to ask if there's any further damage going forward that she address it. This is not anything outside of
Seems
what's
reasonable.
required by the law. I actually think that this is a courtesy to let her know, just like she knew to expect this letter, to say, hey, going forward, we tried to do this with you. And so we have to. I don't want to do that. I would have rather had this resolved.
And this last sentence in the last paragraph, it says, unfortunately, he, the sellers, sold you the house without addressing the tree, therein transferring the liability to address this to you. You think that's fair and respectful to say that to a neighbor?
I think it's helpful. And this is the reason, because again, they had lived in the house for less than a year. They would have been within their right to go back to the previous homeowner and say, you never disclosed this to us. So please give us $1,300 so we can cut back that tree. I would have provided any support or documentation that the Martins needed. I was prepared to be on their team. That's demonstrated in the February 2nd or 4th text. I said it back then, and I'm consistent. And that is one thing that I have been consistent and biased to action through this whole thing, and in good faith tried to protect ourselves and tried to even help the Martins out with this issue.
So you want to be on her team, but you're talking about damages and transferring liability to them.
To the previous owner, absolutely.
Okay.
That's being on Bianca's team, absolutely.
But talking about damages caused by the tree are now going to transfer to the Martin household. That's being on her team?
That's being on her team. I would want that heads up. It's more than I got from you all before you filed the lawsuit. I didn't even get a heads up saying the lawsuit's coming.
Do you see how somebody could take this as a legal threat where they have to go and obtain counsel?
I don't. I will never comprehend that, sir. I'm sorry.
Okay. That's fair. All right, so I want to go to my letter now that was sent. We'll pull that up. Give me 1 second. All right, this is Exhibit P1. Do you recognize this letter?
I do, yes.
Okay. And in this letter, we inform you that a survey had been completed, and we attach a copy of that survey. Is that correct?
That's not how the copy looked that I received. It's much bigger, but yes, in essence, that's correct.
The copy was much bigger?
No, this is much bigger than the copy that I received. It was very illegible, the one that I actually received in the mail.
Okay. And within this letter, I'm looking at the second paragraph, about halfway down. It starts with, the survey is accurate. However, the survey was unable to access an iron pin located in the northwestern corner of the Thomas property, which is your property, due to the fence. And then I say a copy of the survey is enclosed, which shows your fence encroachment.
I see that.
Do you recall reading that at the time?
I do.
She's accusing this guy of sending a little
now,
tiny
you
copy.
Responded
It's like, I didn't send a tiny copy.
A little while later, which is Defendant's Exhibit 2 that we were looking at previously. So you responded via Federal Express to me. Is that correct?
It was within a matter of days.
Sure.
Yes,
I'm just trying to say you did respond to that
letter.
letter.
This is my letter.
Okay.
Correct.
And what exactly are you saying in this letter?
I am asking, well, first of all, I am saying, hey, this is the first time I'm hearing about this. So establishing that I had no prior background to really absorb or understand the letter that you sent to us. I'm also saying, to your point about looking out for your neighbor, this is not the tone that we have set with the Martins. We've always been open and accessible to them. And so I'm surprised that we're here. And it then goes on to list a series of questions that I had about the letter that you had sent. And it also makes you aware of the tree situation, because that was never discussed or ever addressed in any of the communications that you sent with us. So I thought it was important to make sure that you were aware.
And I think it's page 4 and 5. Here are those questions, right? It's like
Correct.
1 through 10?
Yes, correct.
And in this letter, you didn't provide an email address or any kind of phone number to reach you, right?
I did not.
Now, if we go to the second letter that I sent, let me just pull it up. This is Respondent's Exhibit 3.
I just want to play.
And do you recognize this letter?
I do, yes.
Okay. And I answer your questions 1 through 10. Is that correct?
Yes, you provided responses, yes.
Okay. And again, here I say, we look forward to hearing this from you soon. Again, if we can communicate via email, that would speed up this process. Here's my email.
That's
right?
correct.
And you never communicated with me via email. Is that correct?
I exchanged letters with you, but not by, let me just provide context there. I have 3 different jobs. I have 3 different email addresses. I get no less than 100 emails in each of those email addresses every single day. This was of the utmost priority to me. And so I did not want to risk that falling to the bottom of my email inbox. I travel extensively. The way that I manage my life, sir, is that I'm very methodical. Things come into my desk, they get placed on my desk, and I deal with those letters expeditiously. And so this was my way of making sure that I never missed a communication from you all, because that's why I expressed the frustration that I did in my letter to my attorney saying, I'm quick with it. Why are they delaying? I don't understand why this is taking so long. So it was an interest to make sure that these things stay in front of me, front and center.
And I just want to look at number 7 here, the question I'm responding to. So again, I say, can you give me your email address? You were questioning the survey because you couldn't increase the size of it, right?
Yes.
And I wasn't able to provide you additional copy because I never received your email address. Is that correct?
I don't know why you couldn't provide me additional copy. There are lots of ways to do that.
Right.
And I would have loved to receive a FedEx with an enlarged copy again. So that would have prompted me to say, thank you, Mr. Klein. I've received your copy. I appreciate that, like I did every other communication that you sent me.
Number 8, you asked, one of your questions was about the stakes that were placed on the property boundary line. Do you remember that?
Yes, the ones in the front that Brianka testified to, yes.
Right. So you were aware of the stakes as of when?
I was aware, I'm not exactly sure the exact date. I can't testify to the exact date that I was aware of the stakes. I truly don't remember.
It would have been before the lawsuit was filed, right?
I'm saying it at the time of the letter. I can't answer that question with any specificity.
It would have been at some point, at least as of June 20th, 2024, that you knew stakes were on the property.
I can testify, yes, that I say it in the letter, but I can't give you a date that I could provide sworn testimony about.
All right. And then also under number 4, we provided you information about the survey and when that field date took place on February 21st of 2024, right?
That was in response to my question saying the date on the survey was 2013. So yes, that was in response to that question.
And at any time after my first letter or the second letter, you did not allow access to the property and you did not remove the fence. Is that correct?
That was not at hand. At that point, I was trying to understand what we were talking about so that I could figure out the best plan forward to move this forward expeditiously. I said that over and over again in every communication. Not only that, in every communication to you, I had said, hey, I'm shocked that we're still doing this. I am available to speak to Ms. Martin. That would have been the quickest way to get this done.
And you responded to the letter we just looked at from the June 2024 letter from me to you. You responded on July 25th of 2024. Is that correct?
Yes, that's correct.
And this is Respondent's Exhibit number 4 that I have pulled up here.
That's the one.
Under number 1, you say the Martins may not have access to our property to validate an assessment that they have updated multiple times. There have been multiple assertions about the validity of their survey. This should be sufficient for them.
Yes.
You did say that in that letter, right?
That's what's written.
So as of July 25th, you were not allowing access.
As of July 25th, I made that statement, but then I go on to tell you what I'm going to do.
Okay. And you said that you were going to get a survey, an independent survey.
That's correct.
All right. And you never got an independent survey.
I began the process of getting an independent survey and doing my research. Sadly, before I could finish that process, I was served with a lawsuit with the extensive travel, with the board meetings, with trying to manage this from other time zones. I was working as quickly as possible. My hope would have been that I got a follow-up to say, hey, how's that process going? I never got that. I would have even committed to a date to you if I had had that communication. Again, communication has always been open on the receiving end, like never reciprocated.
This letter, though, says that you're going to go and commission an independent survey and essentially get back to us, right?
It said I was going to commission a survey.
Okay. So whose court is the ball in at this point? You say you're going to go get a survey.
I'm taking action. I've testified as to the action that I took.
But we didn't receive any further correspondence in August, September, or the beginning of October. Is that correct?
I was making steps there was nothing to share at that point. I was making steps. I told you I reached out to the surveyor. I got 2 different quotes. That happened from Zurich, Switzerland. Then I followed up with another source and got some information, had conversations from Paris. That was not fruitful. I then understood that I then remembered that I had other physical documentation at my home that I can't access from that point in South America. At that point, then I went to Detroit for a business trip. At that point, I went to Scottsdale to handle a medical situation. And so had you reached out to me, I would have said, hey, I got one last step. I'm going to look at this survey. And then just like I say in points further down, we can have, I said, before I can even consider this, I have to be able to do my own research. And it's amazing how the clock runs super fast when it's in my court, but you guys can sit on an access agreement from February to May of a certain year and not do anything. It's incredible. It's incredible.
Okay. This is the first time that our side is hearing about you being in Zurich and trying to get a survey, potentially from 2 survey companies, right? This is the first time we've heard about it. There's nothing in writing that ever said that.
That I have in writing that what I was going to do. Yes, and I
But
did it.
to us.
It's my testimony that I did it. Yeah.
Correct. But at this time, you never told us any of that.
I told you that I was going to get a survey done, and I took steps to do that. And also, I believe I took steps to do that. I know the company that I reached out to, I've got evidence that I did that.
Even though you've reached out to 2 surveying companies, you've never hired a surveyor to perform a survey on that side of your property, correct?
It wasn't necessary because then I said, hey, let's just forget about the surveys. I'll move the fence. You cut back the tree. Why would I at that point? I'm offering you guys actually a better deal to say, let's just cut this whole survey nonsense. I'll move this. You protect my family by remediating the tree. We don't even have to do all of this. That is in November through Melanie Nealis, to which you all never responded.
I'll get to that part in a second, but when did you actually remove the fence?
We removed the fence January 2026.
Right. When did you remove the other encroachments other than the fence?
So the shrubbery was pulled up. I'd have to look. So the AstroTurf was removed this week. Just about that. The boundary line, the full boundary line was never established. And so we called multiple companies to say, hey, can you come back and pull back the AstroTurf? They had 2 questions. Number 1, back to where? Can't answer that question. And number 2, it's such a tiny job that they weren't interested in it. I don't have the tools to be able to do it. So that is what happened with the turf. The shrubs, somewhere between March and April, but everything was open, and it took like one flick of the wrist to pull up the shrub. So it was available to Ms. Martin. When we discussed mediation, we said, hey, you're welcome to do, we won't hold you.
Your Honor, I want to object to this. This is settlement negotiations after the counterclaim was filed.
All right, let's move on.
All right. Let's go back to this email from
I'm actually
Ms.
with this witness. I think
Niels.
she's in the right.
Yes.
I don't like your
Defendant's
testifying
Exhibit
style,
5.
but
How do you know Ms. Niels? Is she a friend?
She and I met, we worked at the same company, and she's an attorney. 20 years ago, we worked together.
And she's in-house counsel for a company up in Ohio, is that correct?
She is not. She has her own firm.
Okay, but she lives up in Ohio?
She does not.
Okay, where does she live?
She lives in Florida.
Okay. So here's that settlement offer that was made November 18th of 2024, is that correct?
Yes, that's correct.
So this settlement offer is talking about, it says, in exchange for my client's request that your client hire a professional tree service to trim the offending tree, parenthesis, to the satisfaction of an arborist to be retained by my clients, no later than February 28th, 2025. How do we know what this arborist is going to say?
I'm not a professional. Ms. Martin has testified that she's not a professional. So I think it's reasonable to want a professional opinion to say the danger has been mitigated. I can't answer that question.
And then this offer was open. It was made on November 18th, and it was open until November 22nd. Is that correct?
Yes, that's correct.
All right. So that's 4 days?
Yeah, yes.
All right. So it remained open for about 4 days.
That's correct.
Now, if we scroll back up, here's an email from Ms. Nealis, November 22nd, 2024. She says, following up on the settlement offer, is there a response? Correct?
I see that, yes.
All right. And then a couple days later, I responded, not yet. I need to speak with my client on the phone. I'm going to try and connect with her tomorrow. Thanks.
Yes.
Correct?
That's correct.
And then that same day, less than an hour later, she just says, well, they have new counsel, correct?
That is giving you all the information you need, absolutely, to be able to move it forward.
Okay. But by this point, the offer had expired because it was 4 days, right?
Yes.
All right.
It's a limited time offer.
I want to talk about the original fence construction. When was that built?
The original wood fence, the one that Ms. Martin attached to?
The fence that you built, I believe, in 2020.
Yes, that was constructed about summer of 2020.
Okay. And did you hire a surveyor to locate the property line?
We relied on Fence Works of Georgia, which is a professional fence building company, to manage the entire project. So they handled it from start to finish.
So no survey was obtained?
As far, you'd have to ask Fence Works.
Okay. But you're not aware of any survey?
I'm not aware of anything.
Okay. And did you have to get a permit for the fence?
I relied on Fence Works for that, but I can say, so shortly after that, we had a trash pad, like just something that makes it really easy to roll our trash cans out, done by our current landscaper. And and they told us that surveys weren't needed. We actually sit in City of Atlanta. We're not in Brookhaven. And that provides a lot of benefits in terms of not having to have a survey for small projects like that.
Okay. When was the grading work and the artificial turf and the bushes installed?
The bushes were original landscape to the house. So we were very lucky to move into something that had a really great landscape foundation. Okay. The turf was done the turf was installed, DJ graduated, I would say in first quarter 2023.
Okay. Did the turf involve grading work in your backyard?
I don't know what grading work is.
Like removing dirt and trying to level things out?
No, it was already pretty level. Like the landscaping was done.
So just artificial turf was put down on existing dirt?
Yes.
Okay. Did you have to obtain a permit for that?
We hired David Lovett of Garden Craft, and he handled everything. So you'd have to ask him that. All
right. This was another document that was showed to you, I believe, on direct examination. It's marked Exhibit P13.
Yes.
You indicated that, well, first of all, were you ever aware of this?
No.
Okay. Have you ever talked to John Bedson?
I don't know who John Bedson is.
Have you talked to anybody at the City of Atlanta Code Enforcement Department?
I don't know.
Okay. Do you recall anybody coming out to your property on or around June 10th of 2024 or June 12th of 2024?
No, I travel so much. I might not have even been home on that date. I have no idea.
Gotcha. All right, I want to move on to the tree. So when you moved into the property in 2018, the tree was already there, the subject tree.
Yes, sir.
And it was already overhanging onto your roof, is that correct?
Yes, that's right.
Was it causing any issues when you moved in 2018?
It's caused us consistent issues since we've moved in.
Okay.
Yes.
And in 2018, did you contact your neighbors at that time about it?
We contacted our neighbors as soon as we had the first issue with limbs falling down. Yes, that's correct.
Okay. And what was the discussion you had with them?
This discussion was saying, hey, this tree is on your property. The limbs are overhanging. It hangs over our primary bedroom suite. It hangs over our driveway. It hangs over our side yard. And it's caused damage and it's punctured, at this point, the roof. And, would you be willing to remediate that for us?
Okay. And did they trim the tree?
They did not trim the tree, but they directly paid for any repairs that happened. I did not have to spend a dime out of pocket. They hired the contractors, did a lovely job, and we had a great relationship with them.
Okay. Did you ever ask them to trim the tree?
I did,
okay.
Yes.
What was their response to that?
They did not respond either.
Okay.
But
was that a certified letter that you sent them?
It was a certified letter, yes.
He's kind of cutting her off on her answers. I would object.
All right, you can let her finish her answer.
Sure.
Yes. Yes, I did send a certified letter to them.
When did you send that letter to him?
I don't know that I can testify to an exact date. I believe it was 2 communications because we did both neighbors at the same time. We sent a certified letter of our own accord, just writing to say, hey, we've got concerns about the tree. But as we did the research on tree law, then we were like, oh, we're supposed to attach like some sort of professional opinion to this because it can't just be our own personal opinion. And so we sent a second communication.
Okay. And that would have included the peach tree arborist report that was obtained in 2021?
It would have included the arborist report, yes.
You said you sent a certified letter to another neighbor. Is that correct?
Yeah, the neighbor on the other side, because there was a tree also pointing to our house as well.
Since you moved into your property in 2018, how many certified letters have you sent out to neighbors?
That's it.
So 4?
No. We sent, again, let me just be clear. I wrote a letter myself saying, hey, I'm concerned about a tree that is overhanging our yard, and I understand I'm supposed to give you notice. Here it is. Thank you so much. I appreciate it. I sent it to neighbor left and neighbor right. Okay. Then, as we were, moving forward, I realized that that was not sufficient. And so I sent a FedEx to, actually the tree that was on the other neighbor's side was remediated through our construction project. We were able to do that, but we were not able to do the other side because it was on the Martins' property. So that's when we followed up with the FedEx. So if your question is, are we just constantly badgering our neighbors with certified letters? Absolutely not. We've got great relationships with everybody on the street, except for the Martins.
All right. So the 2021 arborist report, which went with a certified letter to the prior owners of the Martin property.
Yes.
They didn't respond to that?
They did. Well, they did not respond directly to it, but they were available if ever we were to want to come over to their property and have a discussion. So the same open door policy that we offered to the Martins very much applied, and we had a cordial relationship. And they remediated damage that their tree had made to the property, which is more than the Martins have ever done over the span of these couple of years.
But yet from 2018 all the way up until now, nobody's ever just trimmed that tree, right?
Nobody's ever trimmed the tree, no.
Okay. Do you agree with me that you could have trimmed the tree?
I don't, because Ms. Martin has proved to be very litigious.
What about prior to 2023?
She can finish that answer.
Yes. Because Ms. Martin has proved to be very litigious. And we've offered, perhaps that could have come up in a conversation with Ms. Martin if she had acted on any of my various attempts to say, the door is open, let's speak, let's be neighborly, let's not involve it. I wish, sir, you seem like a very nice man, but I really wish I wasn't talking to you. I wish I could have talked to Brianka directly and we could have just resolved this.
Understood. Why couldn't the tree have been trimmed by you between 2018 and when the Martins moved in 2023?
Well, because we had already, per our understanding, tried to, because we had already informed the neighbors of their responsibility, so it wasn't our liability. We were trying to follow the letter of the law. I mean, it wasn't our responsibility to trim it. It is squarely on their property.
Okay. I want to pull up an inspection report that y'all had done about a month or two ago. This is Defendant's Exhibit L, treeinspection.com. Do you remember these arborists coming out?
I do.
Okay. And this report indicates that the tree is healthy. Is that correct?
Where are you saying? Can you show me directly to where?
Sure. So let's see here.
There it is. Bullet point starts with discussion.
All right, so observations, the tree has a good structure. Saw also no signs of fungal activity. There are some dead branches. None of the other drills, including on either side of the decay pocket, indicated internal decay. Generally, this report here is saying that the tree is in good condition. Would you agree with me?
No, that was never our concern. It's the branches, and Bianca even said herself, it is the dying limbs, it's the dieback at the top of the tree that has always been the issue. It was very kind of this man to do a full assessment of the tree, but what has never been a disputed fact is that the top crown, which is hundreds of feet up in the air, where the limbs are at least this big in diameter, have been an issue. So
Hundreds
that's
of feet?
great ancillary information, but
Or
it still does
tens?
not negate the fact that the tree needs to be addressed.
Is it a sequoia?
Branches hanging over your side of the property, right?
Yes, sir. Hanging over our home. Yes, absolutely.
And again, you've made no attempt to trim those branches yourself since 2018. Is that correct?
The liability, the responsibility to trim the branches has always been on the neighbor's side.
Right, and that's your position on that. That's what your belief is.
That's what our research about Georgia tree, especially since we've notified the neighbors.
Sir, we Googled
I
it.
wish, again, if we could have had a conversation directly with the Martins on the various occasions that we offered them a conversation, we could have had that conversation. But how do you negotiate with someone who won't speak to you? It's very expensive for Ms. Martin for me to talk to you.
Well, talk to her. Talk to you. Talk to the lawyer. Take the package to the lawyer's office.
And I want to pull up the exhibit here. Give me 1 second.
It's in there?
Okay. Sorry, bear with me 1 second. I'm sorry.
We're bearing, but he'd take too much longer. I'm going to play the song. I've got 2 renditions. I've been making music during the whole. This is great.
Got it. I'm going to pull up what's Respondent's Exhibit N.
Save a tree.
This is in your exhibits, and I think you were questioned about it, correct?
I was questioned about it? Yes.
You were asked about it.
I was asked if I had ever seen it. And yes, recently I've seen this.
Okay. And this here, so this was prepared for Mrs. Martin, correct?
That's correct.
All right. And it was prepared last March, correct?
That is March 13th is what it says. Yes, 2025.
And this here says, job assumes permission granted from neighbor to access driveway to set up. You see that?
That's what it says, yes.
So at least according to this proposal, they would have to access your property to trim this tree. Is that correct?
That's what it says. I don't have any broad knowledge of what it would take.
Okay. Have you ever obtained a proposal to trim the tree?
That has been the responsibility of the neighbors ever since we notified them. I don't know why we would do that.
All right. Have you, so the answer to that is no. You've never obtained a proposal like this one we're looking at?
We've not. What we have done is paid for extensive damages, though, so we've spent our fair share of money.
All right. I want to pull up your Exhibit K, which is this Shingle Pro invoice. You've seen this before, is that correct?
Yes, that's correct.
All right, and when was this obtained?
This was obtained March of this year. That's when the storm came through and we had the puncture on the roof. And that was the invoice that we paid to have that repaired due to a falling limb from that same tree.
And there's a text message between you and the.
I'm going to zoom out on this.
So you asked her to break out some of the damages for the 2,500. You say of the 2,500 that I paid, how much was for the ceiling, drywall repair, and painting?
Yes.
What other items did you have worked on in your house?
We had some more painting done on the interior of our house in the basement.
So it went through the top floor, and the bottom floor, water damage? It's a lot.
And this says I have to send a bill to the lady next door for the amount that I paid you to repair the ceiling. Is that correct?
That's right.
Is that referring to Mrs. Martin?
It is, yes.
And then also you say, please answer soon because I need to send this amount to my lawyer. Is that correct?
That's correct.
All right. I now want to look at some more of the affidavits that were submitted in this case.
Okay.
I swear he said we only had 2
All right,
hours.
I think we've already looked at this one. This one was Defendant's Exhibit J.
Have we hit the 2 hour mark?
And this was your affidavit signed on February 2nd of 2026. Do you remember that?
I do.
All right. At paragraph 6, can you read that to me?
It says the subject fence and any alleged encroachments are removed. See photos depicting property as it currently exists attached hereto.
All right. And at the time that you made this statement on February 2nd of 2026, that was false. Is that correct?
No, that's not true. Again, we did not have a full boundary line. We still to this day have some sort of pin that we can't see in the back and a stake in the front. So to the best of our knowledge, based on the distance between, a connecting point between two lines can be any infinite amount of ways. And so we had no idea between those 2 points where, again, like I said, when I contacted people to help remediate the issue, I could not tell them where to pull anything back to. So at that point, based on our understanding or our guess, frankly, of where that line was, we had done everything that we could. And still to this day, I would say, I'm not quite sure because we keep pulling things back, pulling things back, pulling things back. And it's always something more. It's always another step that we have to do. We even took the extra step when we took down our fence. So because the request was to move the fence, we said, we're just going to take it down because we don't know where else to put it. And we actually came in further into our property because we just didn't know what to do. We spent $2,500 on that fence, and we've essentially taken the full thing down because we don't know where it belongs to this moment.
Well, we know it doesn't belong on their property, but we just.
I want to look at your third affidavit that was submitted in connection with this matter. This is Defendant's Exhibit A.
Yes.
Is this your signature here?
It is.
All right, and this is dated March 30th of 2026. Is
That's
that correct? And if I can go to paragraph 7, if you can read this paragraph for me.
Yes, I can. Since my first affidavit, it was brought to my attention that 2 bushes and around a foot of AstroTurf backyard extended into petitioner's yard now. That goes to the point of I had no idea where the boundary line is. However, as there were no flags, no string, nor any other markers left by petitioner surveyor in the middle of the yard, I could not ascertain the exact new boundary line between our yards in order to remove these alleged encroachments.
All right. You were always aware, though, that we alleged that artificial turf, bushes, and fence were encroaching on the property, correct?
My main concern is where is the boundary line? And I never received that information. I was aware that there were alleged encroachments, but again, limited communication between Brianka, myself, you all, we were not having detailed conversations. So that level of specificity was never discussed directly with me. All I've been concerned with is trying to figure out, well, I wasn't even concerned with figuring out where the boundary line is. All of this activity with finding this pin, with all of this back and forth, with shrubs, with none of that had to happen because, again, in November 2024, we put a settlement offer that would give her what she wanted. It could have been done even before that, as you guys know, because I offered a chance to speak. So
how could you give a settlement offer in November? Number one, it was with 4 days expiration, correct?
we wanted to get it done quickly. And this was a friend of mine trying to resolve it. I was like, there's no way she's not going to agree to both of us just fixing these issues.
And we also had no idea what some arborist was going to come out and say, correct?
We had no information at that point, but I was just ready to solve the issue and settle.
And by that time,
my own detriment, I would say.
And by that time, we had already filed a lawsuit in October of 2024, about a month before that, right?
You filed a lawsuit, that's correct.
And we filed the lawsuit about 3 months after last hearing from you in July of 2024, correct?
Without communicating to me to say, hey, where are you at? Absolutely. I think that would be a great step for you guys to take because it wouldn't have been necessary. I mean, if Ms. Martin really wanted to save attorney's fees, if I was in her position, I'd have said, hey, check with them one more time, see where she's at. Because she made a commitment. She's followed through on every single other commitment that she's made over the course of this time. We have no reason to believe that she wouldn't. So see where she's at.
But again, I didn't have your email address or phone number, correct?
You had a way to contact me. Absolutely.
This is getting petty.
By Federal Express.
Absolutely. 100%. There's next day air. That's a 24-hour endeavor, sir.
All right. I want to go back to another point. You had said that
this judge asking questions.
Even today, your position is you're not sure where that boundary line is. So since October of last year, when we heard testimony that there's now a pin where it should be in the far corner, is that pin visible in any way?
I can't see it. I've actually never physically seen the pin. We just went when her survey came by and said, hey, we found it. We said, okay, great. And that's when we agreed to move the fence.
So, other than them telling you in October that the pin's now in the ground, what is the difference between what you know from the time the first survey came in and that initial demand letter, and then the one that was much later in October 25? Really visually or... did your knowledge actually change at all between those two surveys?
Did my knowledge change between those two surveys?
And again, poorly phrased, but so the first survey that comes in early 24 says that it attaches that diagram as I understand it in P3, but they haven't put the pin in the far corner. And you have some questions about how do surveys work, what's a pin, et cetera. And then you ask for an access agreement so they can come back and confirm things. Now that they've come back since October and say you confirmed that the pin's in the ground, is there really any difference in terms of what your knowledge of where exactly the point is, of where the line is?
I see what you're asking. No, but we were just responding to their request because they themselves said that this wasn't final until they could locate the pin. And so at that point, it's final, and we said, sure. And also to that point, we had the fence down by the end of January. If you look at the first settlement made by Ms. Nealis, what I said to her is I want to give everybody adequate time to remediate their side. And so we gave until, I think in that offer, we said by February 28th of the following year. So as soon as we had that information by which they said that they would consider their analysis final, we acted even more quickly than we gave ourselves time in the first round to take that fence down. Again, I think it's the thing I keep coming back to, Your Honor, is we never even had to go through these paces. because we weren't even requiring, that was their requirement the whole
long answer.
time to come and find this pin. For us, we were ready to act.
But you needed the pin too.
The only other question I have is at the time this settlement offer was made in November of 2024.
Were you in Paris?
You hadn't incurred any attorney's fees at that time, right?
Up to this, as of November 2024, is that?
When Ms. Nealis made the settlement offer.
I paid her $500 to do that. So that was the first attorney's fees that I incurred at that point. Yeah.
Okay. And your settlement offer didn't make an offer to reimburse Ms. Martin's attorney's fees that she had incurred by that time, correct?
Why would it? I never wanted to talk through attorneys. That was her choice.
No further questions, Your Honor. Thank you.
Mr. Miller? All right, you can step down, man.
Thank you.
All right.
All right. I mean, again,
Are we
a few
done?
minutes to clean things up, that's fine, but, you know,
We're out of time.
I feel like we're starting to repeat points and that sort of thing, so I understand the point you're making. All right.
I had planned to call Ms. Nealis by Zoom, but now that the emails have been admitted, Exhibit 5, the defendants, we're just going to stand on those emails. They've all been admitted. So.
I mean, I don't know what her testimony would even add, other than just
Testify just to the emails, so no need.
Okay.
But we'll call Cedric for our last 3 minutes, 3.5
That's fine.
minutes.
Take up one or two more than that, but that's fine.
Cedric, talk fast. Talk fast, Cedric. I do want to see Cedric. Can you show us Cedric?
David. Thanks.
I swear.
Speaking to
Cedric Thomas, CEDRICTHOMAS.
What do you do for work, sir?
Okay, let's get right to it because we only have 3.5 minutes. Tell us about the conversation you had with Keith back in, what was it, March 23rd of
Objection Foundation.
2024.
Right. So I was coming in and he was, I think, inspecting trees that they had just cut down in the front yard. And so since I had noticed they had cut trees down in the front yard, I wanted to ask him what they intended to do about the tree in the backyard, which continued to drop limbs.
Okay, and tell the
Keep
court
going.
about the conversation. What was said? What did he say? What did you say? Those sorts of things.
He basically stated that he was going to have an arborist take a look at the tree, and he kind of like blew me off based off of my own observation.
Okay, did he say when he would do that?
No.
Did he ever do that during the following, what, I guess week
Not
after
to
the
my knowledge.
23rd?
Not to my knowledge.
Okay, then did you author this letter, which has been entered into evidence as, I believe it's G1?
Yes, I did.
Why you did that?
I authored the letter for actually 3 reasons. So one is we just had a storm and we just had damages that we had to pay for the house, and we were tired of paying for damages related to a tree that wasn't in our yard. 2 is, as my wife said, we've seen large trees cause mass destruction to homes before, and also saw the anguish of the owners of these homes having to deal with insurance companies just to get the repairs done, and we didn't want to be in that situation. And 3, primarily because we served the first owner with a letter, and they seemed to be somewhat responsive, and I just didn't feel like I had any other choice.
Okay, and did you consult an attorney in order to write this letter, which is identified as Defendant's Exhibit G1?
No, I did not.
Did you have Brandy look over it?
She reviewed it.
Okay, and did you receive any kind of response from this letter?
No.
Now, what would you like the court to do here? Mr. Thomas?
So this is a situation where I agree with my wife. We don't have to be here. We didn't have to be here, but we obviously had to defend ourselves. We spent tens of thousands of dollars in legal fees over the last 2-year period. So I would want to have that reimbursed to us, as well as the damages that we reported
related to the roof. And the third thing is we would like to have the tree pruned back or taken care of so that we don't have to continue to experience these damages every time we have a storm.
That's all I have, Your Honor. Thank you.
All right. Do we get a verdict? Judge, you can't just take this under advisement. The other guy gets to get up. He gets a final shot at it.
Again, David Klein. We haven't met before. Nice to meet you today.
Nice to meet you.
Just a couple very brief questions. I just wanted to see, did you disagree with any testimony that your wife gave today?
No, I do not.
Okay. And then did you know about the stakes with flags on them since 2024 that were on the property boundary line?
I've seen the stakes, but I can't recall when I first noticed them, though.
And you guys have not hired a surveyor of your own to perform a survey, at least on that side of the property. Is that correct?
No, we did not. We looked into doing so twice, and then we also, I thought that we would have to get a surveyor once we had some other construction done, but that didn't have to happen.
Do you dispute the surveys, the two surveys that we looked at when the expert, Mr. Berhard, was up here? Do you dispute anything in those surveys?
No, I do not.
No further questions, Your Honor. Thank you.
Any redirect?
As far as those surveys go, were you aware that the survey was not completed until October 30th, or it wasn't delivered to us until October 30th of last year?
No, I was not.
That's all I have. Thank you.
All right. Are we done, or do we get the other dad? The other
All
husband?
right. Anything further of Mr. Thomas? Mr. Miller?
We would rely upon, as I said, Exhibit 5 for the testimony of Ms. Nealis.
All right. Sir, you can step down.
Thank you, sir.
Defendant.
All right. Any rebuttal on behalf of the petitioner?
Yeah, Your Honor.
Okay.
The judge is flipping through the law book.
This time we'll consider the evidence closed.
Should we play the music?
And we can get more into substantive and legal arguments here.
They got closings?
I mean, I would say it might be more helpful to go kind of claim by claim, and then rather than just one catch-all argument, if that works. And I'll continue my habit of interrupting if y'all can bear with me. Just so I can direct to the points that I think are more pressing. So I'll just jump right into it, and you can stay seated or you can come to the podium, whatever you prefer. But count one on injunctive relief, as indicated in the order on summary judgment, Mr. Klein. How do you respond to that statute, and generally how equity is not supposed to interfere with trespass unless you talk about trespasser who's insolvent or circumstances showing that we're going to be back here, next month to do this all over again? How do you overcome that hurdle?
Well, again, I mean, I think we've seen a pattern here. First of all, I don't even think that this is an issue necessarily anymore because of what was put in the pretrial order. I wish we could get some kind of an agreement to just agree to that. That's not something that we've been able to agree to, and obviously a statement in pretrial order is not necessarily binding on a party. The only argument I would have is that we engaged with the other side, have been engaging with the other side since April of 2024. Mrs. Martin engaged a little bit, as we've heard, prior to me getting engaged. And the last of the encroachments were only removed yesterday. That puts us, in a pattern of not wanting to move stuff, not wanting to give us access. Things don't get moved until lawsuits filed. You also heard evidence that they don't dispute the survey. They never retain their own survey. Property boundary line was staked. It was flagged. You heard all of that. So, I am worried to a certain extent that this could happen again, or something could be put over the property line. So unfortunately, I think we're still in a position, even though it seems like there is an agreement, in the pretrial order that's not binding on anybody, that we still have to ask for an injunction.
Okay, Mr. Miller, anything you want to respond to as to that claim?
No. Your Honor, as far as the injunctive relief, as we stated in our motion for summary judgment, Georgia law strictly limits the grant of injunctive or other equitable relief to restrain a trespass to certain exceptional circumstances which do not apply here. In the pretrial, we agreed, and the pretrial supersedes all other pleadings. We agreed that we would never put a fence on her property again, nor will we plant bushes, which were actually originally placed there when they bought the property in 2018. And those bushes have been removed. And the only reason why the turf was not removed until yesterday was because she couldn't get a contractor to come out and remove the turf. But the turf is removed now. So we've agreed that we're not going to certainly plant more bushes, certainly put anything else on that property line, which we assume is where we pulled up the bushes. We don't know because the pin in the back was not identified until, was not provided to us until October 30th, which is the evidence last year. And the only thing in the front was a stake with a pink ribbon around it, but there's nothing in the middle. There were never any flags, never any string, nothing. So we just went with our best guess as to where the boundary line is. And it goes back at an angle. It doesn't go back straight. It goes back at an angle.
But it goes back to the pin.
More in the front and a lot less in the back.
But it doesn't curve, right? As long as you know the two endpoints, you could draw a string between the two and you have the line, essentially, right?
Thank you, Judge.
Essentially.
Okay.
But it does go back at an angle, so there's less in the back than there is in the front.
Sure.
So there had to be an angle cut to the turf, for example, and we didn't do that. We just took it up 2 feet in. And the bushes, half of them were over the line and the other half was not. We just took them out. We just assumed that's where they were. But the point is, there's no reason for any injunctive relief. It's a moot question at this point.
All right. Well, yeah, I mean, I think on that point, injunctive release focusing on balancing the equities, the circumstances of this case, although it's been protracted, this isn't a repeated instance over this is happening over and over again. I don't think that statute can be overcome. So I would find in favor of the respondents as to count one. As to count two, the trespass.
No injunction.
Mr. Klein? I would like to know kind of your theory and what damages you believe you've proven and you would be asking for.
So, Your Honor, under OCGA 51-9-1, again, every person is entitled to the, quote, absolute right of enjoyment of private property, and they can recover damages from any person who interferes with that right. The evidence here was undisputed that there was a trespass of the fence, artificial grading, artificial turf, the grading, and the bushes. There hasn't been any other expert here to testify about any other type of survey. Both the 2024 and the 2025 surveys show the same line, show the same encroachments. Now, respondents argue that the innocent trespasser doctrine should apply. They say they relied on this old chain link fence as the boundary, but the innocent trespasser doctrine only protects individuals who enter the land of another under the mistaken belief that it is permissible to do so, and that the unintentional and non-negligent entry does not automatically subject an individual to liability, even though the entry causes harm to the possessor. That's from the McDonald case, 306 Georgia App 641. Our position is that the Thomases received notice of the encroachment in April of 2024 through the demand letters. We included a copy of the survey. We offered to send them a copy of a blown up survey via email if they needed to see more details on that. And so even under the most generous reading of their position, any claim of innocent trespass ended at the date that they were provided notice of a survey, which they don't dispute anything of the survey today. And, you know, in the pretrial brief, the respondents cited to the case of Young versus Faulkner, which is 228 Georgia App 587. In that case, the Court of Appeals held that a trespass was willful as a matter of law because the trespasser had noticed that his belief about the boundary was unsound and he just proceeded with building stuff on it regardless. The court stated there, quote, had the defendant Young wished to do so, he could have tested his belief regarding the boundary line in the courts, and he didn't do so. Or he could have potentially obtained a survey. But this was just a belief that he had. The Thomases, again, received a survey showing the encroachment. They told us that they would get their own survey back in July of 2024. They never did. They never gave us an update. I had no way to contact them other than sending a Federal Express or something, personal service to their address. We never heard anything.
Homing pigeon works.
And so under their own cited authority, the Young case, that trespass was intentional, at least as a minimum after April of 2024. And they can't stand by the innocent trespasser doctrine. Now, the Thomases also point to this connecting of the fence to theirs. I think there's a dispute as to when that connecting fence was actually placed there. They're trying to say that that's some type of form of waiver. I don't believe that there's any authority for that proposition. I believe that the covenant type cases are written agreements that run with the land. Usually for statute of frauds purposes, it has to be a written agreement that's going to run with the land that can be recorded. So really what I think they were trying to argue is some kind of acquiescence of the boundary line. Well, that statute, which is at OCGA 44-4-6, it requires 7 years. So it's basically a prescriptive type easement or an adverse possession, which would require even longer period of time, 20 years. This fence was admittedly built in 2020. We're nowhere near the 7-year requirement. Also, I haven't been able to find any case law that says connecting a fence to an existing structure is somehow a waiver. I think it's clear that everybody thought, at least prior to this survey being done in April of 2020 or in February of 2024, that was the boundary line. I think everybody agrees to that. But once they were placed on notice that, in fact, it was over the boundary line, it needed to be removed, we needed access to their property, they didn't do anything. And we had to file this lawsuit. So we don't think that the innocent trespasser doctrine applies here. What we're asking the court to award, and I can put it up, I have a demonstrative if the court would like to
Is that
see
in
it.
your binder?
It's number 17.
Okay.
I had to recalculate it based on what Mr. Barnhart sent today.
Oh, it's empty.
So I don't have a copy of it, but I can show it to Mr. Miller first to see if he has any objection to it.
I've never seen it.
Well,
I had to create it because of the projections.
And it's not being entered into evidence. You're just using it as a demonstrative. So you can feel free to display it, and then we'll go from there.
Let's see the numbers. Put them up on the big screen for us. Any guesses how much money they're asking for total? What the bottom line is? I'm going to say $50,000. $50,000.
So this is essentially the calculation that we're asking the court to take into consideration. The total lot size is 19,788 square feet. It's about 0.45 acres. If you look at the Fulton County Board of Assessors valuations, which is at P15, that's where we're getting this land value from. So we're basically taking the total amount of the lot that was affected by these encroachments, which
1.74%.
there was testimony that
it's 5%.
At parts it was 1.5 feet up to 3 to 4 feet. So approximately 3 feet of the encroachment width. The length of the fence is approximately 115 feet. So that comes out to 1.74%
So about half the height of the tree.
lot. Very small amount, but still, as a property owner, she was not able to use this portion of the lot. It doesn't matter whether the lot was, or that portion of the property.
This is only page
on the
one.
other side
This is page one.
was not, I think they showed pictures of a can or something like that.
Loss of
That
use.
doesn't matter in
about
terms of the
6,000.
trespass claim. And so we're taking from April of 2023 when she purchased the house to January of 2026 when the fence was finally removed. That's approximately 33 months. and the calculation for total loss of use is about $19,000, $19,817.70.
Whoa.
In addition, we're asking for the out-of-pocket costs that she had to incur related to the survey that she had to come out the first time, survey come out the second time, and then the fence that had to be repaired when the pin was being located.
Okay, well, let's focus on damages for a moment here. I mean,
21,000.
You started here with the survey.
21,000 is the total.
The survey first came about at the request of the landscaper, right? It would have happened. The survey could have come back and there was no fence over the line. It was an open question. So did that really flow from the trespass, or was that something that was just going to happen regardless? And then there's only a second survey because the first one didn't finish the job. Does that flow from the trespass? If it predated even the intentional knowledge of a trespass?
I understand that argument. I think that, again, we would have had to have had a survey.
He's conceding that one.
And then in terms of loss of use, I mean, we're not saying the property was damaged in some way. We're not saying it's
loss of enjoyment.
There's been a lowering in the property value because there was a fence there for a while. And I didn't really hear evidence that that particular 3 foot was just very crucial to the use. I mean, there was talk of maybe a dog. I didn't quite follow why we couldn't own a dog with the fence being 3 foot further in than if it's 3 foot further back. I didn't quite follow that.
Well, I think the testimony from Ms. Martin was that this landscaping plan that she had discussed with the original landscaper, and then landscaping plans that are in the exhibits basically required landscaping to go up into that area. And so she hasn't been able to complete that plan. That's her position on it.
All right. And so, I mean, to me, that's now getting into, and I didn't think this was necessarily, I don't know, let me let you put that. That sounds more like a pain and suffering type argument. You're saying that because I lost 2 years in developing my property, that's the measure of damages here? Are you arguing this is a mental damages of some kind because we lost 2 years of landscaping work?
No, we're not arguing maybe that. We're just saying that the only way to calculate this, I believe, is because there was not an existing structure or a driveway or something like that. The only way to calculate it is based on what is the value of the land, what was the portion of the property that was affected, and that's how we're getting to these numbers. It's loss of use. Again, every single person who owns property has a right to use it or exclude people from it as they deem necessary. So this is the calculation that we thought was the most mathematically simple and accurate, because we're not going to sit here and ask for pain and suffering on a case like this or emotional damages or anything like that. But this is a reasonably calculated number based on the county's own valuation records for only the land, not the house. So that's only including the land valuation.
That's as if they bought
county's
it
own records for that
for 2 years.
Calculating it based on the 1.74% of the property that was affected.
1.74% of the property from the date of your demand letter to today?
We have it in there for 33 months. So that would be when she purchased the property.
All right. And that equals $19,000 approximately?
19,800.
Okay. All right. I'll probably be circling back to you on this point because this, again, is, I think, crucial here. And so I'll turn it over to Mr. Miller. Maybe we can start with that, the willful trespasser defense. It's your burden to show that. And
Believe that we have shown that, Your Honor. If the innocent trespasser is in effect here and it actually bars, and the court should grant a directed verdict on the trespass claim under the case that he cited, the McDonald case, respondents are innocent trespassers and therefore petitioner's claim for trespass should be dismissed.
The innocent trespasser doctrine protects individuals who enter the land of another under the mistaken belief that it is permissible to do so. There was clear testimony, undisputed, that there was a chain link fence.
So I think he's essentially conceding that point, is that the only reason the fence got there to begin with, it's pretty hard to show intent. But his point now is once we gave you that survey and that fence stayed there for another 2 years, that's where that defense gets a little rockier shores here.
Look at the letter that included the survey of April 23rd, 2024. You'll see that they requested two things. They requested to be permitted on the property, and they requested that once we get the survey updated, as the court indicated, that they would ask that the fence be removed. That survey was not updated, not corrected, not provided to us until October 30th of 2025. The fence was removed in January of 2026.
So are you a trespasser in November and December?
Yes.
So within a reasonable time, you're removing the fence. Within 45 days, 90 days, 60 days, you're removing the fence. And I guess that would be the measure of damages as far as any kind of trespass, because the survey wasn't completed until November 1st or October 30th.
Yeah. Just curious, had you come across anything that shows this, when you are put on notice, how much of a grace period you're given? I mean, it seems to make sense to me that you can't instantly be held to account, but perhaps so. And the longer you take, the more you assume the risk that there could be some damages that result. Yeah.
At that point, in October of 2025, the offer had already been made in November of 2024 that the fence would come down. Forget the updated survey, and if you just prune the tree back for $1,300. And that was November 2024.
And I put that all in a box, so that's going to what we'll get to, which is attorney's fees and those findings. But just on a purely liability grounds, at what point, once you've gotten a completed survey, are you expected to have removed the fence?
Once you've got the survey, you've got a lawsuit pending. You've got every attempt under the sun to try to settle the case. And within 60 days of that updated survey, the fence is gone.
Okay.
But I also think that the innocent trespasser rule takes this completely out of the court's discretion or decision, because it applies here full force. The Georgia Court of Appeals has defined a willful trespasser as one who knows that he is wrong. In that case that he cited, the Young versus Faulkner case, the fence in Faulkner did in fact clearly mark the boundary line. And the defendant knew that. In the McDonald case, it states the Georgia Court of Appeals has defined a willful trespasser as one who knows that he's wrong, while an innocent trespasser is one who believes that he is in the right in entering the premises in question. I mean, the fence was built 3 years before Miss Martin bought the property, and it was in place, and it was never complained about. In fact, it was understood to be on the Thomas property. So I don't see how an innocent, it wouldn't take care of the innocent trespasser rule, wouldn't take care of any kind of intentional trespass up until November of 25.
Okay. Yeah. Any responses to the measure of damages they proposed?
Measure of damages are de minimis. I mean, you've seen the pictures from M1 through M8, which show the way the land looked on March 3rd of this year. There was nothing but dirt, rock, glass, cans, trash on this swath of land, which is about 15 feet wide, right beside where the fence used to be. That land has to be taken into consideration as just basically unused land. And on top of that, the tax assessor exhibit is an improper way to measure damages.
Well, they did pay taxes on it.
That kind of evidence has to come in through a state of Georgia certified general appraiser.
and a licensed appraiser. And Ms. Martin is not that. In fact, a licensed appraiser does not use the tax assessor mass appraisal, as it's not utilized to determine fair market value of any sort of land at any point in time. And Ms. Martin testified that she heard that it was 5% based on hearsay. So somebody was talking about that and she heard that. She didn't make any calculations of that amount. And apparently opposing counsel has made these calculations based on a 33-month period, when in fact, at most, it was 2.5 months. So we would object to the use of the tax assessor as any sort of measure of damages. And we would request that the court look at the pictures of the actual land to see how it was used, at least the 12 feet or the 10 or 12 feet that was not impinged by where the fence was. It was unused land completely. In fact, it had trash all over it. So that value is de minimis at best.
So, Mr. Klein, on the issue of intent, the original letter they get that has the survey that you said, well, that was the moment they were put on notice, is one of the conditions. It says that once the, quote, updated survey has been completed, that's when you move your fence. So should that actually be the appropriate point of when the intent is shown, or is it more recently in October?
I think it should be that date. It says in my letter that the survey is accurate. We heard testimony from the surveyor that it was an accurate survey. It was signed by a licensed land surveyor. We also heard evidence that the respondents don't dispute anything on either copy of the survey. So they were on notice of this. They said they were going to get a survey in that response letter, July 25th of 2024, and they never did. They could have gotten a survey during the course of this litigation. They never did. So they were put on notice of a trespass as of my April 2024 letter.
This is one other thing I would point out, since, again, I think damages are a bit convoluted for this claim.
I'd argue that differently.
Under OCGA 51-9-6, damages for continuing trespass, statute cites that damages for a continuing trespass are limited to those which have occurred before an action is commenced. So meaning once you file that complaint, it stops right there. So already I think we have some issues with this calculation, even if we were to go from April to the moment you file your complaint in October.
Well, certainly, Your Honor, the court can still even award nominal damages. I know.
Yeah.
You know, I had a case that went up to the Court of Appeals, and nominal damages of $50,000 were granted on a trespass that actually benefited my client's property.
When did that? I mean, have you seen the Walmart case on nominal damages last year? They've really reined those in. They now say it has to be a trivial amount.
Gotcha.
Important, not for the sum, but justifying the
Yeah,
award.
mine was ASIH versus Vickery Falls.
Always a Walmart.
But did it ever go up on appeal before last year?
It went up, appeal in 2020, I think.
Okay. So I think the Supreme Court really reined that in last June. All right. I mean, I would say that, I'll take a closer look at the record and the exhibits that have been completed here, but I do believe that the innocent trespasser defense has been established here from the date the fence was installed, and so the earliest there could possibly be a finding of intent would be April 23rd, 2024, and that would only continue up until the filing of the action in October. And for that roughly 6-month time frame, the damages that have been established here,
maybe $2,000.
and also I'll look more closely at the damages that flow from trespass. But right now I would not be inclined to say that there is anything more than nominal damages that have been proven here, assuming that intent is also shown. Just based on looking at the exhibits and the testimony, I don't see that use was inclined or impaired to an extent calculable to $20,000. I'll take that under advisement. Just moving on to the remaining two claims, nuisance and negligence. Mr. Klein, I mean, is there a different measure of damages that you're contending flow from those, or are those essentially duplicative?
Those would be duplicative.
Okay. And I think there would be other issues with those. I don't know if we really need to get into them.
What about legal fees?
But I think for the record, if you want to preserve that, Mr. Miller, I think you've already laid out why you think negligence claim fails based on statute of limitations, and for nuisance you said because it was physical encroachment only. Maybe you can repeat that again for me.
That was submitted, Your Honor.
Yeah.
Distinguishing nuisance from trespass. Claim of nuisance may not be brought based solely on a claim of physical taking. In the cases cited there, we would stand on those cases. By contrast, a trespass claim is based solely on the physical taking of the plaintiff's property is itself a wrongful act. Trespass is a distinct direct infringement of the plaintiff's property rights as opposed to an indirect in the case of a nuisance. There's no claim for nuisance on the plaintiff's or the petitioner's part here. It fails to state a claim. And in addition to that, Your Honor, there is evidence certainly now that this fence was put up by Ms. Martin to connect to the other fence. And it would be our position by deriving that benefit of constructing a fence to the other fence, to the Thomas's fence, was in fact a waiver of waiving that location of that fence was in the wrong place. And at least for the year before she had the survey done, she was happy to have that backyard completely enclosed because she erected that fence to connect to it. And then derived the benefit with her and her son of having backyard completely enclosed. And therefore, the covenant and restrictions trial memo does in fact apply here. And the collateral agreement that they had with the prior owners as to the location of the fence would in fact bar their claim because it's a prior agreement that runs with the deed. And Ms. Martin was on full notice of the fence when she moved in, when she visited the property, and then she's on even more notice when she takes advantage of that fence by building a connecting fence to enclose her entire backyard. And it's obvious from the picture. It shows a brand new fence on the side coming off her house, and then it shows a really old fence that was built in 2020 going down the boundary line or going down right next to what they believed was the boundary line formed by the chain link fence, which ran parallel to the wood fence.
Didn't the Thomases
going back to your nuisance argument, is it essentially you're saying there's a distinction here that nuisance has to be an indirect infringement? And so
physical taking.
Okay, and so how do we break that down when it comes to the branch claim? I mean, because that is physically over the property line. Is that not a direct physical infringement? So does this same argument
you can't have it both
yours?
ways? Yes.
Because the branches are continuing nuisance.
Okay. All right, Mr. Klein, anything else you want to be heard on when it comes to the negligence nuisance claims?
Just to respond to that Atlanta Association of Baptist Churches, that's a 1938 case about an implied restrictive covenant in a subdivision development. Again, we take the position it doesn't have any application here to nuisance or trespass or negligence. Again, there was no evidence put up that there was an agreement in writing. There were some vague contentions that,
or even an oral agreement.
I mean, there were some vague contentions about like the neighbors were okay with it, the prior neighbors, but that was about it. So I don't think any kind of acquiescence or covenant issue would apply here.
All right. Well, I think looking at those cases as well, I don't see this case law on covenants and this waiver argument as defeating these claims entirely. They have other issues, but on these particular ones, I don't think there was any evidence, or if there was sufficient evidence to show that there was any kind of an oral or any kind of agreement, rather, that's been proven that was in the deed or made between the petitioner and the prior seller. And I think that you need something more explicit to fall within these line of cases. So, the legal argument's preserved, but I don't think that's going to be determinative here. Rather, there's other aspects that a negligence claim, I think, are going to run into issues here. One, again, usually you have to have proven damages, which already I've kind of indicated. I'm not really overwhelmed by the evidence on that. And
I'm not really overwhelmed.
As to the nuisance, I'll look at that argument otherwise. Okay, but that, I think, really comes down to the only reason we're even still here is because
attorney's fees.
Assuming you get nominal damages on trespass, that could still support an award of attorney's fees under 13-611. And so before I turn it over to you, you want to make any argument you have as it relates to that, Mr. Klein. I just want to make sure that everyone's on the same page, because there's testimony maybe indicating otherwise, that the specific type of attorney's fees we're talking about here today isn't a guarantee of every single cost and an hour that an attorney is billed. It has to be tied to the claim that you win on, if you win on a claim. And so, for example, I just point that out, Mr. Miller, because if you were to win, you're going to have to show me
how much time
you can segregate between the work you spent on one claim versus defending the action. It wouldn't just be automatically all or nothing. And then I'll also point out that again, my understanding of 13-611 is bad faith and stubborn litigiousness and unnecessary trouble and expense. It's not just mere refusal to pay a disputed claim. If there's a bona fide controversy, meaning reasonable minds could disagree and things need to be worked out, that's not stubborn litigiousness. That's not unreasonable trouble and expense. And bad faith is not just bad judgment, but it's intentional. It's conscious indifference, ill will. So it's a high standard. The American rule going back centuries is that when people hire lawyers, they're on the hook and they're expected to pay their own costs. It's not that way elsewhere, but that's our standard. That's kind of the presumption in most cases. So recognize that just because you lose doesn't mean you get attorney's fees, or just because you win. There really has to be a showing of that. So with that, Mr. Klein.
I don't want to belabor I would basically be talking about the same things. We sent in April of 2024, tried to communicate with the other side. I couldn't get an email address. I couldn't get a phone number. We sent follow-ups to their questions, answered all their questions, and we still couldn't get access. And then we waited another almost 3 months to file the lawsuit. And now they said they were going to get a survey. They never did. You heard testimony from Mr. Thomas that he doesn't dispute anything in the 2 copies of the survey that we had. So it's absolutely shown that there was a trespass here. I don't think that there was a bona fide dispute as to whether there was a trespass here. So for that alone, I think we should be getting the vast majority of our attorney's fees, because throughout most of this case up until a couple of days ago, the only claims that we had were trespass, injunctive relief, and then the ancillary claim for attorney's fees. You heard testimony from Mrs. Martin. She didn't want to be in this position. We felt like we had to file the lawsuit because of the March 27th letter, the text messages, and then the seeming unwillingness to cooperate. And I understand their position on that they were sending these letters via FedEx to be, making sure that, their rights were preserved, et cetera. But why couldn't I get a phone number? Why couldn't I get an email? And not hearing anything for another 3 months after they said a survey would be commissioned. I don't really know what other option was other than to just wait around.
Was there any communication that you sent to them that they did not respond to eventually?
No.
Okay.
But again, the ball was in their court. They said they were going to get a survey. And that's where it left us. So, and by the time that settlement offer was made by their prior counsel, she had already incurred attorney's fees related to those letters. She had already incurred attorney's fees related to the drafting of the lawsuit, filing the lawsuit, serving the lawsuit, et cetera. And there was never an offer made to compensate her for those attorney's fees. Also in that settlement offer, I think there's a dispute as I think the term what the arborist specifications are, or to the arborist specifications, the tree should be debranched. The branch is taken off. What does that mean? That I had 4 days to respond to a settlement offer on this particular issue, and then I was told, well, it's being turned over to new counsel, and we did make attempts to try and get something resolved in the course of the litigation, but at that point we were already going out to the property and more attorney's fees being incurred. So we would ask for our attorney's fees to at least be given back on the trespass claim, Your Honor.
Well, just since you bring it up, we might as well just get into it too. The other claim for the nuisance now with the branches. I think your client essentially conceded liability on this. I think she said that I agree that there are branches and that those cause harm. So do you have any dispute that if a tree is entirely on one side of the property, that the branches go over to the neighbors, that the tree owner has the responsibility for those branches and that tree?
So the case that I cited, the Willis case, 184 Georgia App 349, it says if they're aware of something that they can prune or trim, which they've been aware of it since 2018. They had communications with the prior neighbor since 2018, where they could have gone up there, taken care of the branches that were overhanging. And as long as they didn't damage or kill the tree, which is undisputedly in good condition, then they're under an obligation to do that. That is what this Willis case says.
Is the Willis case, though, distinguishable because the tree is on the boundary line?
I don't think so.
That's a pretty key point. Like, they both owned the tree. And that makes a point of that in the Willis case, saying that they both had this joint responsibility over the tree because it's right there on the line. Well, this one, there's no question who the tree belongs to.
Correct. The base of the tree the tree belongs on her side of the property. But again, there's a self-help doctrine in Georgia, and they were aware of these branches since 2018.
Self-help
They could have gone out there, pruned and trimmed them. They never did. They just allowed, allegedly these branches to come down on their roof, come down on their house.
Well, and they're not even, well, I guess they are now because there's something that happened in March. But up to this point, they weren't asking you for damages that predated the lawsuit. They just said, this is now a nuisance. You need to abate the nuisance. And so, and I think, again, your client said, I agree, it's a problem. And so, okay, set aside the damage that they're saying happened in March. Did your client not admit liability to needing to abate the nuisance at her expense?
No, because again, I think that they've had this issue since 2018. They know that they could have pruned the tree. We have a report from a tree company saying that it has to be done from their side of the property. So as long as they didn't kill or damage the tree, they could have pruned this tree at any time they wanted to. So I think, I don't know what there is to abate when they could have abated it themselves.
But, okay, fine. So they should send you a bill for it? They should do it and send you a bill? The question is who pays?
Well, I think it's their responsibility.
And why so if the tree's entirely on her line and it's her nuisance?
Well, I don't think it is her nuisance. Again, these are overhanging branches. This happens all the time in Georgia. If I have a tree in my backyard where things are overhanging, I just cut it. And that's what you're allowed to do in these situations. So I think they had a responsibility since 2018 to do this. And instead, they just had a situation where I guess the prior neighbor was just reimbursing their damages. I don't really understand that, why it was never pruned for the last 7 or 8 years.
So, I know you cite the Willis case, but is there anything else you can point to me that shows that in this kind of a fact pattern the branches going over a line become the responsibility, the sole responsibility in your position of the neighbor?
I don't right now, but if he wants to make an argument, I can do some research briefly.
And I'll just point out to the issue he raised in one of these memos about duty to mitigate. I mean, if you look in our pattern instructions for tort claims, it says that with continuous torts, that doctrine doesn't apply. So setting aside the 1909 case that Mr. Miller found, it looks like our pattern instructions and some more recent cases echo that point. So if there is no duty to lessen or duty to mitigate to a continuous tort, what then is the defense to the liability of the nuisance that's claimed here? And right now I'm not seeing one. All right, I'll turn it over to you, Mr. Miller.
Miss Martin is losing.
First of all, I don't know why he's saying he couldn't call Brandy. I mean, Brandy left several voicemail messages, or one voicemail message on the 24th of April with Miss Martin. Miss Martin had Brandy's phone number. So at any point in time during the summer of 24, Mr. Klein could have picked up the phone and called Brandy because Miss Martin had her phone number. So that argument, I don't know where he's coming from with that. In addition, as you pointed out, the Willis case was about a tree that was on the boundary line. Here we have a tree that's definitely located on her property. The law in Georgia is that once a tree owner is put on notice that that tree has dead branches or is looking like it's dead or whatever, if it falls or causes any damage to the neighboring property, it is the responsibility of that homeowner that owns the tree. In fact, it's the responsibility of that homeowner's insurance company to take care of that tree damage that occurred to the neighbor. Now, if the tree doesn't have any noticeable damage or noticeable rot or dead branches or whatever, then the neighbor has to take care of it. Thomas was that. Their insurance company would have to take care of it. But in this instance, the Thomases
Detectives, thank you very
exactly
much.
what
OG.
they thought they needed to do was to put her on notice that, in fact, once you're on notice that there are dead branches, and we got this report from 2021, let's work together and let's do something about it. And that's what that text was about. It was all about sorority sister. Let's get together and let's get the prior owners to do something for you with this tree.
What
And
if
that's
the
what it
event?
was all about.
What if the event
And in
Miss
fact,
Martin's going to hold is a sorority reunion?
Brandy, at the end of that text message, said, quite frankly, I want to deal with you. I don't want to deal with attorneys. Let's just talk about it. And Ms. Martin refused to do that. She refused to do that to the point where she said, Keith's going to take care of it. Well, Keith blew off Cedric as they were having other trees removed in their yard on the 23rd of March. And then they gave him a letter, official letter, with the text, with the report. And they knew that there was a report from 2021 which showed this is a hazardous tree. Let's do something about it. And the next thing you know, they get an attorney letter from Mr. Klein. And as the court pointed out, that letter stated, once we get the completed survey, it doesn't matter whether the survey was accurate or not. His letter said, once we get a completed survey, then we want you to remove the fence. And that's what the letter said in April of 24. Now, fast forward to November of 24, you've got Ms. Nealis involved, and she quite clearly made an offer to say, forget about the survey, forget about completing the survey. This is November of 24. Let's just prune the tree. We'll pay to have the fence taken down.
And I see that as the bad faith. But if their original position was, hey, look, your fence is over the line. We're going to confirm it later. And once we confirm it, we want you to remove the fence. But then a couple months later, they're told, we're not going to let you confirm it. We don't want you back on the property. how can then they ever follow up and give you that completed survey? And I know you did, it later happened, but at some point in there when it's, nope, you're not allowed back on the property to confirm it. Now, aren't you just left with a survey's already been sent to you and your fence is over the line on that survey? We don't know exactly where, but it is over the line. Why not just remove the fence and then follow up later to figure out exactly where the pin is?
Because at that point in time, Brandy was not represented. He could have received a call at any point in time from Mr. Klein, and his letter was sent on June 20th. One letter was sent on July 25th, and nothing's happening in August other than Brandy's trying to get a survey done, and she's getting hit with all the things that
life.
get hit with.
I get it.
And at any point in time, he could have called, but he turns around and files a lawsuit instead. There was never any demand to say, okay, you've got the survey, now you've got to remove the fence. There was only the demand in April to say, once we complete the survey, then we will ask you to remove the fence.
What are you asking for in attorney's fees?
What's the number?
We were asking for, I don't know that, I'd like to see the case on that, because I don't know that I have to split out my attorney's fees as to the counterclaim, the nuisance claim, as opposed to the defense of the main claims that came through. I don't know that I can split that out, but our attorney's fees are in the neighborhood of $46,000. And that is after a $15,000 credit that I gave to the Thomases based on the fees that were incurred here. And the majority of those fees are within the last 2 months.
Those are all you, that's all your work? That doesn't include?
How much?
That includes the King.
Okay.
As well.
All right.
How much?
The majority of those fees are due to the hearing on the motions, the mediation, the inspection, and prep for trial.
Yeah.
That is our claim, Your Honor, and I think it's fully supported by our exhibits, especially Ms. Neela's emails, which I would point out, they never came back to Ms. Neela's and said, okay, you want us to prune back the tree to the satisfaction of an arborist. What do you mean by that? Give us an idea of what an arborist is going to require us to do. Let's go out there and have an arborist take a look at the tree and, move forward with this settlement. There was none of that occurring at that point in time. It was just a total stonewall at that point in time because Ms. Neela's, as you'll see from these emails, she was contacting Mr. Klein like every other day trying to find out, what's going on. Let's get this thing settled. We want to get it done. I mean, Ms. Thomas testified she wanted to get this behind her. And that offer was very reasonable for both parties, and it would have taken care of everything at that point in time. And we're talking November of 2024. Now, the extension on the answer, additionally, trying to get a settlement, and then never were able to do it. As far as the access agreement, they were provided access in January, February of 25. They never accessed the survey pin until September of 25. It seemed like there was a constant delay on the part of the petitioner, and there was a constant trying to get stuff done and trying to get it behind us on the part of the respondents. As far as the answer filing date, as far as the access agreement, as far as the survey pin finally being located and determined to be the actual boundary. And the fence was removed within 60 days thereafter, which I think is a very reasonable amount of time with a lawsuit pending against you, where the other side is refusing to settle the case and or prune back a tree, which is obviously they have admitted was a dangerous tree right over their bedroom, right over their garage, and right over their driveway where they enter their house every day of the week. So we think we're entitled to attorney's fees under 13611. We think we've shown bad faith. And I would point out that in our brief, petitioner's claim for attorney's fees should be dismissed
An award of fees is only authorized where the evidence reveals that the defendant acted in bad faith. Attorney's fees may not be awarded if the action allegedly in bad faith was prompted by an honest mistake as to one's rights or duties. Obviously, they put the fence there in the first place because the neighbors wanted it, because they thought and understood that it was on their property because it was on the other side of this black chain link fence, which was a bad one. That's the only reason why they put the fence in that place. And the neighbors were in total agreement with it. They wanted it. There can be no finding of 13611 claims under the case of Brown versus Baker at 197 Georgia Appeals, 466, 467, 1990 case, and also Bowen versus Laird, 348 Georgia Appeals, 1 and page 3, a 2018 case. Here, the evidence clearly indicates the respondent's alleged trespass was prompted by an honest mistake based on a chain link fence that pre-existed respondent's purchase of the property, petitioner's purchase of the property, and the agreement that this formed the boundary of the Martin property. Respondents corrected this mistake soon after receiving accurate notice on October 30th, 2026. So we think we're entitled to attorney's fees for bad faith and for unnecessary trouble and expense, which this has definitely been at least since November 24, when the offer was made, prune back the tree, we'll take down the fence. Thank you.
All right, thank you, Mr. Miller. Mr. Klein, if you just anything and everything you want to address, just have the last word here.
Sure. I mean, I'm performing research right now while we're talking about this waiver issue relating to the nuisance or a mitigation issue relating to the nuisance. Honestly, I would like some time to address that. This is the first time that I saw that in the trial memorandum. So I've been trying to cobble together what I can on that issue.
Well, I'll tell you, the waiver thing I'd already said, I wasn't really seeing any connection there in the case law. The duty to mitigate, I think, is something that is worth addressing.
I just want to correct, the access agreement was not signed until June of 2025. We took steps to get out there as quickly as possible. I mean, if you want to see all the emails, I'm not going to show them to you, but there was a lot of back and forth between the attorneys. Hey, can we do this date? No, can't do this date. And then finally, we got a date we agreed on where everybody could be out there. So it's not like the delay is just completely on our side of the coin here. But I don't think there was bad faith here. She had a reasonable belief that, number one, the tree issue should have been taken care of by them. She had an arborist or tree company come out there in March of 2025. They said that it could easily be pruned, but it had to be done from the Thomas's side of the property.
So if the law is quote unquote well settled, that if a tree's on your side, you're responsible if it falls.
Mm-hmm. Responsible.
How's that a bona fide controversy?
Insurance covers it.
Well, the tree didn't fall. I mean,
well, or I think that could be extended to a part of a tree falls, which would be a branch, right?
Branch.
Yeah.
I mean, again, I think that a branch and a tree falling are two different things. I mean, tree falling and splitting a house in half versus a branch that may or may not have caused some damage to a roof. I think that's completely different. It's definitely different in a situation like this, where this has been going on since 2018, prior to us even purchasing the property.
There's so much money wasted in this trial.
Is there anything else you wanted to address?
No, Your Honor.
So are you requesting to supplement on some of these legal points?
I just need to supplement on the waiver issue that we want to talk about relating to the nuisance and their actions since 2018. I'm finding some case law about this, but again, I haven't had enough time to research the issue.
All right. How much time do you want?
I mean, I can get it to you by Monday at the latest.
Monday?
Okay.
We're busy Monday.
So I think I've already kind of given you some preliminary rulings on some of these claims. Again, the one I would be most interested in hearing from you, Mr. Klein, is
nuisance.
How you think that and why you would think that it's a bona fide controversy that I know we've said this over and over again, but that if the branches go onto your land, then that makes you responsible for what happens, even if the tree is located entirely on the other side of the boundary line. And without having done too much of a deep dive, we pulled up Georgia DOT versus Smith, 2012 case, 314 Georgia Appeals 412, just giving that vanilla statement of it's well established that if there's a defective tree, here are the rules of negligence that Mr. Miller outlined, where if there's knowledge that there's some defect, then and that tree falls, who's responsible? I don't see why those same principles wouldn't apply to branches if they're falling from a tree. And again, there's knowledge that there are issues with it. And so the claim you made that the reason there's a bona fide controversy, the reason she didn't offer to prune and pay those pruning fees immediately was because she thought that they're the ones who should have to pay that. I would just like to see the legal support for that. And then if you said you wanted to follow up on this duty to mitigate issue as it relates to nuisance claims, you can do that too. And today's Friday. If you really, are you going to spend all day Monday on that? We can just do end of the week next week. Yeah. And I don't know, Mr. Miller, if that's something you want to respond to or not. I mean, I think I've got your arguments. You can if you want to. I don't want to tell you to spend more time on this than you already have.
Me too, Your Honor.
Okay.
I'll reserve the right once I read his brief, but I doubt it.
All right. So we'll say Friday next week, close of business for any written response. From there, I'll enter a final or non-final judgment as to the specific claims. Let me put it this way. If I find that there is liability on the attorney's fees, then we'd follow up, and I mean, I'll have the parties confer, but essentially have you submit whatever prevailing side, whether it's, you can submit what your fees are. If there's an objection to that amount, preserving the issue of the reasonableness of them, but to the amount, we'll schedule for a hearing as is required. So I don't know if am I clear on the procedure there? All right. I'll enter a finding on the claims. I'll direct you to file evidence of whatever attorney's fees you have to support them. And unless there's an objection, that will then be made the final order. But if there's an objection to the amount, we'll have a hearing on the amount, and we'll go from there. All right. Thank you, counsel. We're off the record.
Thank you, Aaron.
Wow. So it's a slow-going trial. I like this, mostly because I got in a fight with a neighbor once about a tree. And here's my take on this. Let me give you this take. First of all, the Thomases, they're the ones who owned the big fence that had to come out. I think it should have been argued that they had a responsibility when they were building the fence, even if they were tearing another one out and putting one in its place. They had a responsibility to make sure it was in the right place. That should have been the better argument. As far as the tree goes, I think the judge is clearly right. The Martins have admitted responsibility for the tree. It is on our side. If branches fall, that's our problem. But if branches don't fall, I think the way it should be, and I'm not the Georgia law expert, but where I did research this in other states, it should be something to the effect of the Thomases can trim the tree back to the property line, the real property line, and they have the right to do that. If it kills the tree, then they have to pay for the tree because they damaged the tree, but they have the right to trim it back. If anything falls, that's going to be on the Martins, and usually insurance covers that. And the way insurance fixes that, they say, we're going to drop you off our insurance unless you trim that tree. And so it's all taken care of. And then we don't have to pay $49,000 to our lawyers, and we don't have to fight with each other over stupid things like this. And in this time, while we were listening, we made a song. We made a little song, and I'd like to play it for you here. Because we can't go into the weekend without a little song, right? So let's see. I've got two versions. Three, actually, but I think I'll just play two. Let's see if this one works.
On our cul-de-sac in Atlanta, where the azaleas fight for space, We were sisters in the same chapter till their white fence crossed the place. He said he sat too far left. I said, girl, check the survey line. Now we both got flower beds talking like it's court night every time. We smiled through the HOA, then we didn't for a while. You took that fence down piece by piece and folded up your pride with a towel. That fence is gone now, gone now, gone now. You want that tree cut back, back now, back now. Dead limbs over your yard, you say they might fall hard, and I still got your package in my garage by the mower cart. Amazon sent it to my porch with your name and my address. It's been sitting by the broom rack in a cardboard dress. You asked if I trim your tree since you pulled the whole fence loose. Now I'm looking at that dead limb like, baby, that's your truce. We wore the same letters, same pins at Rush Week.
Rush Week.
Now we're measuring cedar boards and talking through the screen. That fence is gone now, gone now, gone now. You want that tree cut back, back now, back now. Dead limbs over your yard, you said it might fall hard, and I still got your package in my garage by the mower cart. Baby, we can swap some kindness, maybe settle this clean. You get your limbs taken care of, I'll hand you what's in between. I'll bring it out in a tote bag. You can laugh, then we move on. Two ex-sisters on the sidewalk, trying to make the whole thing go. That fence is gone now, gone now, gone now. You want that tree cut back, back now, back now. Dead limbs over your yard, you said it might fall hard, and I still got your package in my garage by the mower cart. That fence is gone now, gone now, gone now. Come get your package and let that dead limb chart his own course.
All right, so there was one. Do you want to hear the other? Because it's very different. It's somewhat different. I'll let you vote. We'll have two songs because it's Friday and we're wrapping up for the day, and so I'll let you vote on which one you like best. Here we go. Here's the Peachtree package. Let's give it. I think it's this one. Oh, it would be that one if I turn the volume back up. Let's try that again. Okay, here we go. 3, 2, 1.
On the side of Atlanta, where the azaleas lean, you drew a fence in summer right down on that seam. We were both in letters, same sorority pen. Now we wave like strangers when the trash truck rolls in. County map on the counter, tape measure in your hand. You said that ain't your corner. I said, girl, I understand. Then you tore it all back down, left the nails in a jar. Now you're asking me for favors from my yard to your car. Peachtree package still in my garage, still got your name on it, still got my boss. You took that fence away, now I'm asking for grace. Trim that dead tree back. my yard to your car. Peachtree package, still in my garage. Still got your name on it, still got my balls. You took that fence away, now I'm asking for grace. Trim that dead tree back before it lands on your place. Peachtree package, still in my garage.
My favorite part. This is Amber on the violin.
Both got stubborn, baby, we both got pride. Two porch swing queens in a one-line fight. I can hand you back the box if you call to settle right. Come get what came for you and I'll let it go tonight. Peachtree package, still in my garage. Still got your name on it, still got my balls. You took that fence away, now I'm asking for grace. Trim that dead tree back before it lands on your place. Peachtree package, still in my garage.
There we go. Packaged in my garage still. All right. there we've got two more songs. So we've got Garage Package. We'll go ahead and let you guys find that one. It's going to be published. And then we also have the Peachtree Package. So you can listen whenever you want on our magic playlist. I don't know why I said magic. It's just our playlist. There's nothing magic about it. But they're both available on our Suno list. We do make those songs using the AI, so that's the AI portion of the song. I create a little bit of the lyrics and steer it a little bit and how I want it to sound, and the AI does partial creation on there. So there we go. So obviously, any resemblance to any facts of an actual case is purely coincidental. That was just some random song we came up with. So there we go. All right. With that, we're done for the day. On Monday, we have a real case to follow. It's out of Ohio. It's out of Warren County, Ohio. It's the courtroom that's always on, never stops. The live stream never stops. So we have to be here on time. We cannot be late, because if we're late, we miss it. But we're going to be there. I think it's not Judge Teep. It's the other guy. Who's the other guy? I forget. But we have a dynamic duo who are charged with felonious assault. I remember there's another charge as well, but felonious is my favorite word today. So we're just talking about that one. And we have an amazing thumbnail to show you on Monday when that goes live. Judge Peeler, thank you very much. Don't miss the forest for the trees, greeners. Thank you. Mary, we're trying to fix an issue because channels that show court feed, like a live feed from court where a pew-pew is displayed, are getting struck, and they're losing their ability to stream because of YouTube Terms of Service. Now, Terms of Service, as I read it, news events, political and news events, are covered as an exception to that. I mean, it's specifically allowed, like a firearm in that. So for instance, you got police out doing their thing. If you can't get struck every time you show a police officer with a pew-pew. So we're trying to work that out. It does, in the short term, it's hurting the channel, but we're trying to figure things out, and we'll work on that going on. We've been breaking news for a long time. I mean, you look at our logos, even on our thumbnails for years. We've said we're the home of true crime and breaking news. So, all right, that's it. That's all I've got for you today. It's Friday. The weekend's here. I hope you have plans. Well, thank you, Red, for posting this. Aggravated burglary, first-degree felonies, and felonious assault. So burglary and felonious assault. Excellent. I'm looking forward to that one. So a real trial. And then after that, I just saw that our other Ohio trial, and that's the Caleb Flynn trial. Look, I remembered his name first try. He's asked for another continuance. And I don't know if he's going to get it. I'm watching a little bit for that. But that one might be delayed a little further into May or beyond. So we have that. Anyway, my advice for you to this weekend, when you're going out in your yard, check your trees, look up, just look at the property line, see if there's anything that's overhanging, and if there is something that's a problem, so it hangs over your neighbor's yard, or his garage, or his house, or his pool, or something, whatever it is, go right back in your house, close the door, walk into your kitchen, bake a plate of cookies, serve a couple up on a paper plate, go over, knock on the door, and say, hey, neighbor, I brought you some cookies. By the way, I've got a problem with this tree. How do we want to fix it? Do you need me to cut this down? We'll do it. Because $1,300 to cut down a tree is a dang sight cheaper than $49,000 in legal fees, which you might have to shell out of pocket. That's my advice for today. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again on Monday morning with a trial out of Ohio, Warren County. You guys, I'm stoked for the weekend. I think I've got a gig tomorrow. I've got a little gig. It's just audio only, no cameras. But that's going to be fun. And then I got a call from another people saying, hey, you do audio stuff? So I might have another gig in May. So we'll see. Thank you, guys. You guys are amazing. Be good. Be safe. We've got a lot of you in our prayers. I know several of you are going through some really heavy things. We're trying to remember everybody's name for that. Please know that we do hear what you're going through, and we're trying as best we can on our side to intervene with the powers that be to make things better. So please be safe. Love y'all. You guys have a good one. Bye-bye.
There's nothing in the order that restrains you from talking to cats.
Thank you.
What more do you need to see?
Happy birthday. You look good.
Don't miss the forest for the trees.